typographical error be detected, a numerical one place is testament. In the first page, Lordship, Bulbul Sen expired on 19th. On the second page, it is on 9th. So it will correct is
19th September?
Yes.
9th November.
19th September.
19th September.
First page is correct.
So appearing for the petitioner. The petitioner has mentioned the matter before this court for correction in the order dated 10th of January 2025. It is submitted that in the said order at page number 2, paragraph 2, line number 3, the date of Bulbul Sen and the date of death of Bulbul Sen has wrongly recorded as 9th of November 2018 instead of 19th September 2018. Accordingly, in the order dated 10th of January 2025, page 2, paragraph 2, line number 3, the date of death of Bulbul Sen shall be read as 19th September 2018 instead of 9th November 2018. This order may be incorporated with the order dated 10th of January 2022.
My lord, may I be permitted to one bench matter? It's a probate matter, my lord. 1 week time was given for the filing of the stamp duty, but there was some affixation of stamp duty on the page, on this page. So I want to have 1 week time at least.
Which year?
Just a few days back, 1 week back.
So what you want?
Just a stamp duty. I want to file the stamp duty.
File in the department.
They said that 1 week extension is expired, so I have to take permission from the lordship.
Where is the order? Probate is granted.
Yes, my lord.
Then
They 1 week extension was given to us.
when?
Just when your lordship passed the order,
Which line the time was given to court fee? Show me the.
in the department they said 1 week time is elapsed and we have to take permission
For what?
for filing the stamp duty. My lord.
Court has not granted. Court has granted the probate to you. You have not submitted the bond before the department. So why you are placing the burden upon the court?
Just at least 1 day time
What, sir?
for filing a stamp duty, my lord.
Kindly read the order. What the order passed is the court has passed an order directing you to file the deposit the court fee.
Yes.
Then where is it? Yes.
May I permit to mention some of the probate matter for the necessary direction to be passed in section 283(3).
Right.
Another matter, one of the general citation to be issued.
My lord, may I permitted to mention for correction of order dated 15 January, my lord. There is a mistake in recording, my lord. It has been recorded the plaintiff has filed an application under for GA3, my lord, but it has been filed by the defendant, my lord. And my lord, one more thing, my lord. On 4th of September, my lord, we filed, my lord, written notes of argument, my lord. It has not been recorded, my lord, in the order.
Which order?
On 4th of September, my lord, we filed an written notes of argument regarding, my lord, GA3, my lord.
But where is the question of filing written notes of argument? This is affidavit in opposition. What?
Yes, my lord.
All persons are making fool this court.
No, my lord, we filed it.
4th September, what is the order?
At first, my lord, we think we have.
Yes, call next.
My lord, for correction, my lord, my lord.
Yes.
May I be permitted to mention this is probate application in the year 2023. Everything has been completed and no caveat certificate has been issued. This is ready for hearing. My lord, kindly takes up the matter any day.
My lord, may I be permitted to mention the testamentary matter, my lord? May it appear in the list for issuance of the citation and publication.
Ma'am, my lords, kindly leave to mention 2 commercial suits. Your lordship, we have instructions from our client to withdraw the same. So if your lordship kindly keeps it as to be mentioned on Monday, we'll.
Have you got the instruction?
Yes, your lordship. I'm carrying the instruction.
Monday for withdraw.
My lord, I'm
To be mentioned for withdraw.
Mentioning upon notice, your lordship. Grateful.
Yes.
My lord, I'm mentioning a matter to be
Oh,
listed.
senior is there.
I'm sorry for mentioning well the advocate on record is ill, but the monthly list matter of 78 is a testamentary matter, is a TS. Now, if she's
What is the
no,
state?
issues has to be framed. Inspect discovery
For the
issues.
other side.
No, I've given notice. I'm mentioning upon notice to Nivedita Pal, the advocate on record. It is monthly list 78.
Take
So,
some.
78.
Yes.
My lord, I'm mentioning a matter to be listed under the testamentary. I'm mentioning a matter to be listed under the testamentary matters as per your lordship convenience.
For what?
For PLA matter.
For what? Ready matter?
Yeah, ready matter.
Yes.
My lord, order is required to be drawn up within a week, and that time is elapsed, my lord.
Sir, this court has not passed any order for week or 1 month. It is a
We understand, my
department.
lord.
So how the court can extend? If the court has passed any order fixing a time, the court can extend. Let the department come with the report. Send the report.
We began to file the requisite.
What requisite?
They are asking for leave
What leave, sir?
because I have not filed within 7 days. Order dated 6th of January.
Say the complete.
Yes, my lord. 6th
To
of
say the complete and draw.
complete and draw. Complete and draw, my lord. Complete and draw.
Sorry, my lord. I'm extremely sorry, my lord.
চিঠি করেন this.
Your lordship, I am appearing on behalf of the plaintiff. This matter has come up at my instance, your lordship. The difficulty is, my lord, this plaintiff was admitted, your lordship, on 20th December 24, subject to scrutiny by the department. Now, my lord, the department has, subject to scrutiny, your lordship, it has pointed out that the verification which is attached to the statement of truth is not in the proper form. So, your lordship, I'm seeking for a leave that it may be filed in a proper form within a week, your lordship. That's my prayer.
What is the difficulty in the verification?
Your lordship, they are saying it is not in form, so it has to be in. এটা একটু দিয়ে দিই আমার shoot করতে। Your lordship, page 19, your lordship, it has to be আমার কাছে আছে এই পেজটা দিয়ে নিন না your lordship কে দিন। Your lordship, it has to be the only, your lordship, it was, your lordship, the concerned department is a master, your lordship. The master had also requested the concerned officials, my lord, that may it be overlooked. It's not because the plaintiff has been admitted by your lordship, but this department is creating issues, your lordship, for each and every single thing.
Where is that? The original plaintiff is not here.
Your lordship, the file.
Plaintiff है? या नहीं है?
Lordship,
तो लीव कहाँ ग्रांट करेगा?
CS com 820. 820. Your lordship, I'm grateful.
For order, item number 2.
Yeah. Warning is done. Item number 2. None appears on behalf of either of the parties. No accommodation is sought for. The matter was listed on 3rd of January 2025. On the said date also none appears on behalf of either of the parties. Accordingly, this court has sent the matter placed the matter in the warning list. In spite of placing the matter in the warning list, none appears on behalf of after placing the matter in the warning list, the matter is again placed before this court today. Today also, when the matter is called, none appears on behalf of either parties. No accommodation is sought for. No accommodation is sought for. In view of the above, CSCOM 9 of 2023 within bracket नाम दे देना. Glorious Investment Limited versus India Tire and Rubbers Company Limited is dismissed for default. Interim order, if any, stand vacated.
Item number 3.
Same order. Dismissed for default.
Number 4.
Same. Dismissed. Item number 3, na? including interlocutory application. Interlocutory application also dismissed. Dismissed.
Lordship, in this matter, I beg to appear on behalf of the plaintiff. Lordship, in this matter, I have taken out an application because the summon was served way back in June, both by speed post and by the sheriff's office.
Writ of summon.
Yes, yes.
Hmm.
To that effect, I have filed an application.
Hmm.
I would straight away draw your lordship's kind attention to Annexure A. That is the
GA1.
yes, GA1.
What is the application for?
This is my application praying for transferring this cause as an undefended cause because the statutorily mandated timeline for filing the written statement has
Where is
expired.
the writ of summon report? Where is the report of the department?
Yes, your lordship would kindly take page 8 of my application.
Page 8. Sole defendant.
Yes, sole defendant. That's the sole
Duplicate
proprietor.
copy of the original census speed per second. 6/6 and 4/6.
Yes.
2 dates.
Yes. Your lordship would kindly also take
Not entered
Annexure B.
Not entered appearance.
Now, this petition was also served upon them and they have received an
So appearing for the plaintiff. The plaintiff has filed the present application being GA-Com 1 of 2025. Praying for placing the suit being CS-Com number 1 of 61, CS-Com 659 of 2024 in the list of undefended suit. Counsel for the plaintiff has disclosed the mode of service issued by the Deputy Sheriff of Calcutta dated 19th of December 2024, wherein it reveals that writ of summon by both the ways have been served upon the defendant on 6/6/2024, 4/6/2024 and 6/6/2024. The plaintiff has also relied upon the report issued by the Deputy Registrar Legal of this court dated 23rd December 2024, wherein it is certified that the defendant has not entered appearance either in person through the advocate. But the learned counsel for the plaintiff peruse the report as indicated above. This court find that the defendant, in spite of receipt of the writ of summon, failed to appear before this court and also not file any written statement. Accordingly, CS-Com 659 of 2024 be placed in the list of undefended suit. GA-Com 1 of 2024 is disposed of. Full stop. The plaintiff is directed to file the judge's brief of document within 2 weeks.
fortnight's time.
Within 2 weeks. Full stop. The plaintiff is also directed to file the affidavit of evidence of the plaintiff witness within a week thereafter. Full stop. Please the matter give the date of witness action. 10th of March at 2 p.m. for witness action.
I'm so grateful to you, lordship. I'm grateful, my lord.
Item number 10, your lordship, and for the plaintiff petitioner, we were supposed to file our affidavits. My affidavit in reply is ready. It is just about to be affirmed. I can, if your lordship directs, I can serve an unaffirmed copy upon my learned friend. Kindly keeps it on any other day.
Lord, I'm being led by Mr. Amarjit Kumar. He's appearing.
Yeah, affidavit is ready. Your lordship can record it. It is just about to be affirmed. It will be affirmed today. Your lordship grants me 1 day's accommodation. I can file it in court.
No, today only we can file it.
We can file it in the course of the day. And in the meantime, we can serve an unaffirmed copy upon my learned friend.
So appearing for the plaintiff. So appearing for the defendants. Counsel for the plaintiff submitted. His affidavit in reply is ready and will affirm in the course of the day and will serve the copy of the same to the learned counsel for the defendant in course of the day. In view of the submission made by the counsel for the plaintiff, the case adjourned. Let the matter appear
28th,
28.
My lords, it can be 30, my lords. On 30th, my lords. Or
30,
second.
30 is a Thursday. I am not taking the commercial matter. Then 31st?
My lords, 31st. My lords, either 31st or second, whatever my lords be.
That is holiday, 31st January.
Please, my lords.
31st. Next.
Lord, I appear
My contempt
for
application.
the contemners.
Yes.
Lord, pursuant to your lordship's last order, my lord,
Lord,
if
I
we were to
humbly
give an
beseech your
undertaking,
lordship. Yes, my lord, if lordship sees my affidavit, but there are 3 affidavits filed. If lordship will take one of the affidavit, but I would humbly beseech your lordship, if lordship kindly takes the affidavit of my lord Ghazi Murshidal, which has been affirmed on 8th of September 2022. It's a very
Ghazi Murshidal.
yes.
Yes.
Who is Murad the contender number 1?
Hmm.
Murad, the order that was passed on 3rd of September 2021. Murad, the order of, is that there was an order in terms of prayer C of the notice of motion. Now, Murad, notice of motion says that I will not use the mark IIHM in any manner whatsoever. Murad, I am not using the mark IIHM that your lordship will find from the affidavit, because Murad, the domain name after the order of 3rd of September, we have changed it to IIHM Kolkata. Lordship kindly takes page 21 of that affidavit.
Yes.
Page 21 onwards, Malad. In fact, Malad, what was there before, the domain name previously was IIHM Kolkata, which has been suspended. Malad, this document, Malad, Lordship sees, Malad, page 21, although it is not clear, but Malad, IIHM, Malad, there is an averment in the affidavit. Lordship will see the averment. Malad, kindly see, Malad, page 9, paragraph 5. Page 9, paragraph 5.
Yes.
Malad, kindly see the last line of page 9, paragraph 5. In terms of the order dated 3rd September 2021, I have not used the domain name. The last line at page 9. I have not used the domain name iihmkolkata.com. I have, after the orders dated such and such, not used the domain name iihmkolkata.com. In fact, under my instructions, the domain name iihmkolkata stands suspended. This averment is supported by the document which is appearing at page 21. Now, Mulad, the act, apart from me using IIHM Kolkata domain name, it has also been alleged in the contempt petition that, Mulad, third parties or educational institutions were informed regarding the mark IIHM Kolkata. Like, I was still communicating with other educational institutions that IIHM Kolkata is my mark. Mulad, that is not correct. Lordship will see page 22 onwards of my affidavit. In fact, Mulad, even before the order, Lordship sees page 22. Mulad, this is an email dated 12th of January 2021.
Correct.
And kindly see, Mulad, this was written to collegedekho.com. Because one of the acts of contempt that have been alleged in the contempt petition is that I am notifying these educational institutions regarding the impugned mark IIHM. Now, kindly see my email of 12th of January. This email is as a reminder notification of not using IIHM for our college. We would only be addressed as Indian Institute of Hotel Management in all your advertising, campaign, promotion, and any other activity as mentioned earlier. Also, do not use our logo without our permission in any of your activities. And now do not use logo of address us as IIHM anywhere. If done, At your end, please do the needful and make all necessary corrections and changes.
Correct.
But I have informed, my lord, this is to collegedekho.com. Now, Lordship sees, my lord, page 23 of my affidavit. The self-same email was all.
Where you find the college?
My lord,
Yes, yes.
to
Yes.
hello@collegedekho.com. Now, Lordship sees page 23. My lord, this is again, my lord, on 12th of January on the same day. This is to collegedunia.com. This is to collegedunia.com.
College Dunia, where it is?
Yes, my lord, Lordship sees there is an I. My lord, there's a small I just beneath that, contact@collegedunia.com.
Yes.
The same mail was also issued to collegedunia.com.
Correct.
Now, Lordship will kindly turn the page and come to page 24. Here again, my lord, Lordship will see the small I and the recipients of the email, my lord, sales@shiksha.com and dean_sbihm@yahoo.com.
Yes.
My lord, we have on, but this is before passing of the order of 3rd of September that we inform them that please do not use IIHM for our college. Now, my lord, the next allegation was, my lord, that I have been publishing and in materials, advertising brochures, IIHM mark. But that is incorrect. Lordship will find that from page 25 onwards.
Yes.
Page 25 onwards, IIHM mark or acronym or logo was no longer used. I'm using the complete full form Indian Institute of Hotel Management. But kindly comes to, my lord, page 27 once. 27, my lord, this is a newspaper publication. My lord, the date is, my lord, 28th of August 2022. It's in Bengali because, my lord, the Bengali date Lordship will find in the left hand top corner. 28th of August 2022. Mr. Ghosh can confirm the date.
He's telling that he don't know the Bangalore language on the last occasion. Yes.
Yes, my lord, kindly see my educational brochure, which is appearing at page 27. My lord, it bears the complete name, Indian Institute of Hotel Management. I am no longer using IIHM. This is page 27. Now, Lordship will kindly see page 29. When I am participating in, my lord, educational programs, page 29.
But page 27.
Yes.
Indian Institute, but before that IIHM is not there. That is allowed.
Name is allowed, website is not.
My lord, but the order is, if Lordship sees prayer C of the notice of motion, page 75, volume 1 of the contempt petition. I'm sorry, my lord, volume 2 of the contempt petition, page 75.
Yes.
Yes, my lord, the impugned logo, Lordship will find that at prayer C, page 76. My lord, the order is, I am injuncted from using the expression mark or logo or acronym IIHM or IIHM as part of its business name or style in any manner whatsoever.
Come to 27.
Yes, 27.
IIHM, then Indian Institute of Hotel Management.
Yes, I will not use IIHM alone.
Logo, kindly see injunction restraining them or any of them, whether themselves or through their men, servants, through their distributor, stockist, and so logo or acquirum IIHM or IHM as part of the business.
Yes, part of its business. Here, my lord, I am using the entire name.
That you using, then there is no problem. Institute of Hotel Management, that court has given you.
Yes.
But with regard to prior to that, you have used the IIHM. What about that? Can you?
No, my lord, if Lordship sees my lord, it's only, my lord, it is, my lord, this mark that your Lordship is seeing under a hat, just above, my lord, it's not the.
What is there in the
Huh? Yes, my lord, if Lordship says this IIHM is,
good design.
it's
He's
not
not
the.
permitted to use it because prayer C, which was granted, and based on which the interim order was confirmed.
তুমি এই চারটে শব্দ ইউজ করতে পারো না।
Exactly.
That's why. That is the only.
Yeah, now my lord, the email has
That's
come.
why on the last day I asked
He was
him.
supposed to come and just give an undertaking that he
Yeah,
will
I
not
am ready.
use it.
Yeah, I am also ready with the undertaking. I have received an email from my client on 15th of January that we will not use this in any manner whatsoever.
We have a copy of it.
আর একটা email দাও। ঠিক আছে।
My lord, the person who is issuing the email, I do not think he's any one of the contemners.
Rajiv Sen is one of the contemners.
Who is Rajiv Sen?
সারা গাজী। মানে এটা কে দিয়েছে দেখি?
Director at IHM.
হ্যাঁ।
Who's Subroto Vishwas?
সুব্রত নয়, সুরভিত বিষয় is the advocate on record.
Advocate on
না না,
record.
ডাইরেক্টরটা কে? Who has issued the email? Who has issued the email? এই যে ইমেলটা দিয়েছে,
Who's director?
লোকের নামটা কি?
Ghazi Muslim.
Ghazi Murshidul has to issue.
Rajiv and
Rajiv Sen has to issue.
These are the two persons.
And my lord, somebody on behalf of Indian Institute of Hotel Management, it's a firm. And so there cannot be any question of a director being there.
Yes, that's correct. Mr. Ghosh is correct.
Does this
Issued by the Rajiv Sen.
you do one thing.
No, I'll do one thing. I'll revise the undertaking.
Revise and come with a small supplementary affidavit
Very well.
enclosing this and one of the director who is present director of this.
So it has to be a partner because it's
Yes.
a firm.
Yes, yes.
Present who is holding the post of the director who has issued this. Let he come and file a supplementary affidavit.
Very well.
Undertaking that they are not going to
Correct.
use the word IIHM
And he will
as
use the
as
form of the
injuncted in
Indian
prayer.
institution.
Yes.
That nothing else. That is the only on the last occasion I told to the. So and so appearing for the petitioner, so and so appearing for the alleged contemners. Full stop. The alleged contemners produced the email issued by the alleged contemner stating that they will not use the logo of IIHM. But this court find that the email has not been issued by the contemner and it is also not clear whether the said email was issued by the present director who is having any present director. In view of the above, the petitioner, the alleged contemners are directed to file a supplementary affidavit stating that they will not use the IIHM and comply with the order passed by this, comply with the interim order passed by this court.
That is all.
Let this at supplementary within a week.
Kindly gives me 10 days, my lord.
Within 10 days from date, let the matter appear on 7th February.
Great. I'm not standing in the way because they are willing to comply.
Correct.
Because otherwise, a rule should have been issued. Because they've already filed their
They already filed.
Yes, well, let them file. I'll have nothing to do.
Grateful, my lord.
I am here for the plaintiff, my lord.
I am for the defendant number 325, my lord.
Uh,
And this is my application for extension of time to file the written statement, my lord. Lord, yesterday I had taken leave from my lord and filed it in the department. Lord, though after filing it was marked defective because my lord, being a commercial suit, written a statement of truth and list of
that is
documents.
different thing. Have you filed the written statement in the department?
Yes, without the statement of truth and list of
filed.
documents. Yes, my lord. But that because those two documents are not there, it was marked as defective.
When you receive the writ of summons?
Writ of summons was received by me, my lord, on 23rd September.
23rd?
23rd September 2024.
23rd September. When you affirm the affidavit of the written statement?
Affidavit was affirmed on
Written statement.
written statement was affirmed on 3rd January.
And when it was filed in the department?
Yesterday, my lord.
So what is the date? How many days?
Within
120 days.
Within 120 days. I have a copy, if my lord can serve it.
Very good. Take it.
A copy is being served, my lord. The written statement.
And the statement of truth.
I shall file those within 1 day, my lord.
So and so appearing for the plaintiff. So and so appearing for the
Within 120 days.
all defendants, for all
No,
defendants.
my lord. Defendant 3, 4, and 5.
Defendant number 3, 4, and 5. Police counsel for the defendant number 3, 4, and 5 had filed the master summons. being GA Com 2 of 2024,
116 day, on Monday.
paying
time
for
on-
extension of
according to-
time to file return statement. The counsel for the defendant number 3, 4, and 5 submit that writ of summons was served on
23rd September, my lord.
23rd September
You
2024.
have a counterclaim?
4. But due to inadvertence, return statement could not be filed and affirmed within the prescribed period of 30 days. But have affirmed the return statement when the return statement was affirmed?
3rd of January.
3rd January 2025, and is filed in the department on tomorrow, yesterday,
my lord. It was
Uh,
16th.
on 16th of January 2025, with the liberty of this court. Full stop. Full stop. Consider the submission made by the counsel for the counsel for the plaintiff raised objection and submitted that the defendant number 3, 4, and 5 have not shown any cogent reason as to why they have not filed the written statement within a period of 30 days. Heard the learned counsel for the respective parties peruse the heard the learned counsel for the respective parties. This court find that the defendant has filed the written statement within the order time period of 120 days. And as such, one opportunity should be given to the defendant to file written statement. Accordingly, the department is directed to accept the written statement filed on 16th of January 2025, subject to scrutiny. Police of the defendant number 3, counsel for the defendant number 3, 4, and 5 is also directed to serve the copy of the written statement to the learned counsel for the
Already
plaintiff.
served, my lord.
The counsel for the defendant number 3, 4, and 5 already served the copy of the written statement to the learned counsel appearing for the plaintiff. Police appearance. Learned counsel for the defendant number 3, 4, and 5 submit that though they have filed the written statement, but
Statement of truth and list of documents.
the statement of truth and list of document is not enclosed with the written statement, and please submit that he will file by
By Monday, my lord. That will
By-
be on a 19th day.
20th.
20,
he will file
it is
the
20th.
statement of truth and list of document by
20th January. my lord.
28th of January 2025. Consider the submission made by the counsel for the plaintiff. Leave is granted to the counsel for the defendant number 3, 4, and 5. Leave is granted to the defendant number 3, 4, and 5 to file their written statement of truth along with the documents relied by the defendant on or before 28th of January 2025 by serving the copy to the learned counsel for the plaintiff. GA number disposed of.
Grateful.
Your Lordship, I appear on behalf of the plaintiff, Your Lordship. Your Lordship, page number 19, that is the verification of the statement of truth, Your Lordship. Leave may be granted to file. Please verify the same, Your Lordship.
List of defects. There are so many defects.
My lord, those defects, my lord, that has been done by Your Lordship in the before the learned master, Your Lordship. Only these leave has to be required by the learned Honorable Court, Your Lordship.
Leave is granted to the plaintiff to file a fresh statement of truth.
Lordship, verification.
Fresh
Your Lordship,
verification.
Your Lordship.
Within
7 days, Your Lordship.
Within-
My client has to come, Your Lordship.
within a week from date.
Your Lordship,
Within a week from date.
I'm grateful.
My lord, this is my application, my lord, for summary judgment under Order 13A of CPC, my lord. This matter, my lord, I have sold and supplied the gold ornament to Senco Jewelers. My lord. So against the invoices, my lord.
Have you obtained report?
Yes, my lord, I have obtained a report.
Where is that?
Yes, my lord.
They have not entered appearance.
They have not entered appearance, my lord. Till 3rd of January 2025.
Where the writ of summons was served?
Yes, my lord. Writ of summons was served on, my lord, 10th of September 2024, my lord.
Where is that report?
I have obtained the report, my lord, from.
Okay. So what do you want now?
But I pray for a summary judgment, my lord.
But let the suit become as undefended suit. It can be disposed
My
of.
lord, in chapter 13A, my lord, this order 13A, your lordship has earlier passed summary judgment on this application, my lord. There is no defense. May I
What
place,
is
my lord?
chapter 13?
Yes, my lord. This is order 13A of commercial.
Order 13 or chapter 13?
Order 13A of Commercial Court Act, my lord, CPC, my lord. And my lord, sufficient time has been given. Kindly see the Commercial Court Act, my lord. Commercial Court, they have already provided, because at the time of filing, their department give them 30 clear days to file their reply, my lord. Kindly see, my lord, order 13A, section grounds 3, 4, procedure 2, my lord. Procedure 2, then 3, my lord. The respondent may, within 30 days of the receipt of
That's
notice.
correct. I am not on that. I am telling once you have filed the application under order 13A of the amended CPC in terms of the commercial code, there is no problem at all. But now the question my suggestion is that once the defendant has not entered appearance,
Yes.
correct, the suit will go as a undefended suit. So let the come as a defendant suit to argue the matter. It can be disposed of.
Mr. Malor, in this case, when the there is no defense, Malor, when the check is dishonored, and then the Malor, the question of the witness, evidence of witness of the plaintiff is not required at this stage, because there is no defense. They are not coming.
I am not telling
and
with
prima
regard to
facie,
the defendant.
the earlier lordship has passed this order on the dishonor of the check, my lord. May I place, my lord, this against the same company, Senco, my lord. They are not appearing, my lord, because they don't have any defense to. Checks were issued and it was dishonored. Earlier, 2 cases, my lord, your lordship has passed this summary judgment and decree was passed, my lord, on this application.
Yes, show me.
My lord, kindly see, my lord, the invoices, my lord. 3 invoices, my lord. I have.
Where is the first you have supplied the gold ornament? Gold coins?
Gold ornaments.
Ornaments.
New
Where
gold
is-
ornaments, my lord.
Where is that?
Kindly see, my lord, page 26, my lord.
Page
Page
26.
26, there are 3 invoices.
Page 26.
26.
Yes.
Ganesh Jewelry, 13/2/2024.
New ornaments.
New ornaments, my lord.
22 carat, 916, 297 gram.
My lord. Page 27.
17 lakh 87,374.
Yes, my lord.
Along with the GST, 18 lakhs. This is the total.
Yes, my lord.
Correct. Where is the receipt? They have received?
Yes, my lord. In the on the side, my lord.
Who is the defendant?
Defendant is my lord, Senco Jewelers.
Senco
Private
Jewelers.
Limited.
Where is that they have received this?
Yes, my lord. Kindly see the right side, my lord. Left side, my lord. It is their stamp is there. Senco Jewelers Private Limited.
Purchaser.
Purchaser, my lord.
Yes. Then
next bill also 15/7/2004. Page 27.
This is 13th February. First one, 26.
13 February 2024.
And then
next
15
is
July.
15th February 2024, my lord.
Yes, then.
And 16th February 2024, my lord.
Correct.
Page 28. These are the 3 invoices.
Correct.
Against that, my lord, the company has issued a check. Kindly come to page 29, my lord. Annexure B.
Correct.
They have issued this check to Ganesh Jewelry.
18 lakh 84,000.
My lord.
This is for one.
Yes, my lord. They have issued 4 checks.
Where is the 4 checks? All are there.
Yes, my lord.
So this has been dishonored.
Dishonored, my lord. Dishonored, my lord. Can you see
Insufficient fund.
Funds insufficient.
Correct.
Page 31, my lord. Another check, 18 lakhs 40,000.
Okay. Then till
Dishonored.
36 is your dishonor.
Yes, my lord.
Then thereafter.
Thereafter, page 33, my lord. It is 10 lakhs.
Okay.
This is also dishonored.
Correct. Then 37 notice.
35 also dishonored, my lord. Then, my lord, I have given notice on 26th of April 2024.
How many checks he has issued?
3 checks, my lord.
Three checks.
Three.
One is the 18th April. Second is also 18 April.
No, four checks. Total four checks, ma'am.
4 checks and 4 transactions.
Against the three invoices.
Three invoices.
Three invoices, madam.
Yeah, then notice
Then,
is,
madam, notice was served on them.
Hmm.
Kindly see the page
10
41, my lord. They have received the notice.
41.
Page 41.
Hmm.
Acknowledgement card is there.
Hmm.
They have received the notice, my lord.
Hmm.
Page 42 also, my lord.
Hmm.
Then the track report is also filed, my lord. Page 43 and 44, 45.
Delivered.
Delivered, my lord.
Hmm. Then
Thereafter, madam, I have filed a application before the mediation, my lord. Mediation, they did not turn up, my lord, and they have given report for the non-starter. Page 47, my lord. This is of 26th July 2024, my lord. So they have, my lord, there is no defense to this, my lord. My humble prayer is, my lord, kindly pass the decree.
so this court has become a negotiable instrument court.
I'm a small jeweler, my lord. I'm supplying to them, and now the gold prices are from 60,000 to now it's 78,000, my lord.
Full stop. None appears on behalf of the defendant. Full stop. The plaintiff has relied upon, and the plaintiff has filed the present application under order 13 capital A of the Commercial Code Act of the Code of Civil Procedure as amended under the Commercial Code Act for summary judgment. Full stop. Counsel for the plaintiff submits that the writ of summon was duly served. Writ of summon of the present present suit was duly served upon the defendant on 10th of September 2024. But in spite of receipt of the writ of summon, the defendant has not entered appearance. Full stop. The plaintiff has also relied upon the report of the Deputy Registrar Legal dated 3rd January 2025, wherein it is certified that the defendant has not entered appearance. Full stop. The plaintiff has supplied new gold ornaments to the defendant on 13th of February 2024 for a total amount of rupees 80,40,996. Has supplied the following gold. Has supplied the gold ornament, the new gold ornaments for a total amount of 18,40,996, 15 July. That is the 15 July or 15 February?
15 February.
Page 27.
15 February, my lord.
On 15 February 2024 for a total sum of rupees 18,84,947. On 16th February 2024 for a total sum of rupees 16,39,438. In spite of receipt of the said gold ornaments and the invoices raised by the plaintiff, the defendant has not paid the accordingly. Subsequently, the plaintiff and the defendant had issued a check dated 18/4/2024 for an amount of rupees 18,84,947. All are 18/4. Date all are 18/4. Check.
Two checks of 18.
Two checks.
I have mentioned, my lord, in page, my lord, page
18/4/2024.
page 16, I have mentioned.
For an amount of 18,84,947 and 18,40,996. And further two checks have been issued on
22nd April.
on 22nd April 2024 for a sum of rupees 10 lakh and rupees 6,39,438 respectively. Counsel for the plaintiff submit that the check issued by the defendant represented by the plaintiff for realization of the said amount, but all the checks have been returned with the endorsement insufficient fund. A fund insufficient, inward fund insufficient. After return dishonor of the checks issued by the defendant, the plaintiff had issued notice to the defendant on 26th of April 2024, calling upon the defendants calling upon the defendant to pay the amount as per the gold ornaments received by the defendant, as the checks issued by the defendant have been dishonored with the reason funds insufficient. The notice issued by the plaintiff were duly served upon the defendant, but in spite of the receipt of the notice, defendant has neither sent any reply nor had paid any amount to the plaintiff. The plaintiff had initiated a pre-institution mediation process before the mediation center of this court. In spite of receipt of the notice of the mediation center, the defendant has not appeared in the said mediation process, and non-starter report has been submitted by the authority on 26th of July 2024. And on receipt of the non-starter report, plaintiff has filed the present suit. So, learned counsel appearing for the plaintiff submit that the admitted in the document which the plaintiff has relied proves that the plaintiff has supplied the gold ornaments, and the checks issued by the defendant to the plaintiff admits that the defendant is liable to pay the said amount. Full stop. In spite of full stop, and as such, said amount, and as such, the defendant is not having any defense to defend the suit, and the plaintiff is entitled to get the summary judgment. Consider the submission made by the counsel for the plaintiff, peruse the application and the documents available on record. This could find that the plaintiff has supplied the gold ornaments as per the requirement of the defendant, and the defendant has accepted the same along with the tax invoices raised by the plaintiff. After receipt of the gold ornaments and the tax invoices, the defendant has issued 4 checks for realization of the said amount. But when the plaintiff has presented the said check for realization, all the checks issued by the defendant have been dishonored with the reason funds insufficient. Full stop. After the dishonor of the check, the plaintiff had sent a notice to the defendant informing that the check issued by the defendant has been dishonored, and as such, plaintiff has called upon the defendant to pay the said amount. In spite of receipt of the notice, neither the defendant has sent any reply nor had paid the amount to the plaintiff. Even the defendant not choose to appear before the mediation center in the mediation process initiated by the plaintiff. Full stop. Considering the above, this could find that full stop. This could also find that even after receipt of the writ of summons as well as the notice of the present application, the defendant not choose to appear before this court to contest the suit and the application filed by the plaintiff. Considering the above, this court find that the defendant has no defense and the plaintiff is entitled to get the summary judgment. In view of the above, the defendant is directed
Page 21, my
to pay rupees 53,65,381 to the plaintiff, along with interest at the rate of 18% per annum from this interest calculated from which date to which date?
My lord, I have calculated, my lord, this
Page 12, kindly page 18.
from the bill date, my lord.
There are several what is the last bill date?
Last bill 22nd April, my lord.
No, bill date. 15 July.
My lord, 22nd April was the last bill date.
No. 15th.
Date.
22nd April.
16th of February. 16th of February 2024, my lord, is the last bill date.
16th of February. From क्या बोला? From 16th February 2024 till the realization of the said amount. Full stop. As the suit filed by the plaintiff is commercial in nature and is filed in the commercial division of this court. Full stop. In spite of the writ of summons and the copy of this application, the defendant failed to appear before this court. In spite of receipt of the notice after the dishonor of the check, the defendant failed to pay the amount to the plaintiff, and the defendant compelled the plaintiff to file the present suit. Accordingly, the plaintiff is also entitled to cost of rupees 1 lakh.
I'm grateful.
The defendant is directed to pay the cost of rupees 1 lakh within 60 days from date, failing which the amount of the cost of rupees 1 lakh shall carry interest at the rate of 8% per annum till the realization.
I'm grateful.
CS number so and so disposed of, decree be drawn accordingly.
Lord recalls this is my application. This is pertaining to, my lord, striking out of defense of, my lord, the defendants, in as much as they have failed to comply with your lordship's order of August 2024. But may I file my affidavit in reply to the application which had taken?
Application which GA?
GF5, my lord.
GF5 filed by you?
Yes, my lord, it's my application.
What is the prayer?
Applications for striking out of defense of the defendants in as much as they have failed to disclose any documents and comply with directions of discovery and inspection in terms of Order 11, Rule 21 of the Code of Civil Procedure.
Yes.
Now, my lord, we have exchanged affidavits. They have not taken they have no defense as to why they have failed to disclose documents for inspection. They have only said that we have delayed our own suit by filing an application for disclosure of further documents before the coordinate bench. And the coordinate bench was hearing the matter, and the coordinate bench has disposed of the application, allowing that further documents be disclosed. But apropos this present application, in where, my lord, my only contention is this, that despite of several opportunities granted, they have failed to disclose documents. They have taken inspection of my documents, but no documents have come from there, and neither have they offered inspection at all. So, my lord, in light of the same, if your lordship is pleased to consider Order 11, Rule 21.
Just a minute. GA bit also. Huh? Order 11?
Rule 21.
Who is for the defendant?
I'm appearing for the defendant number 1. I'm being led by Mr. Shumon Dutt in this matter.
Lordship sees the last two orders. First is an order of...
You ready? You ready?
Yes, your lord.
Order 11?
Rule 21. where any party fails to comply with any order to answer interrogatories or discovery or inspection of documents, he shall, if a plaintiff, be liable to have a suit dismissed for want of prosecution, and if a defendant, to have his defense, if any, struck out, and to be placed in the same position as if he had not defended. Now, my lord, if your lordship sees your lordship's order of 27th of September,
Yes.
my lord, the second paragraph from the first page,
Order dated?
27th September, my lord.
Yes.
By third last paragraph from the first page of the order, my lord, by an order of 13th August 24, this court directed the parties to complete discovery and inspection of the documents and to exchange their suggested issues. Today, when the matter is called, counsel for the plaintiff has filed the affidavit of documents after serving copy to the learned counsel for the defendants that the same be kept on record. Is submitted by the parties that they will complete inspection of documents within 2 weeks after Puja vacation. In view of submissions made by the counsel for respective party and for the interest of justice, time to complete discovery inspection of documents is extended for a further period of 2 weeks. This was the extension on 13th August. The initial order was passed. Now, my lord, if your lordship takes up the order of 17th of December,
Where is that?
lordship, may I hand up that copy?
Yes.
The plaintiff filed the present application for praying of striking off the defense of the defendant on ground in spite of several opportunities given by this court and the request made by the plaintiff in terms of the order of this court. Defendant has not disclosed documents for inspection. As such, he is prayed for striking out of the defense affidavit directions. Now, if your lordship is pleased to take up their affidavit, which has been served on us. So before I go to the affidavit, in my application,
Where is your affidavit? Filed?
It's filed. with your
Where?
lordship.
well, in the application itself, if your lordship is, I'm sorry, your lordship, I'm taking your lordship back to the application. Well, 2 letters, September 19, 2024, at page 11. Where I offer inspection. Last paragraph of page 11, my lord. You may take inspection of the originals of the documents any day next week. Then, my lord, on November 13, 2024, which is at page 14, my lord, please refer to the order dated September 27, passed by his lordship. We write to record that in spite of our letter of 19 September 24 offering inspection of the originals of the documents to be relied on by our client in the suit, your client have not till date obtained the inspection of the same. We therefore request you to please give inspection of the originals of the documents to be relied on behalf of your client in the suit of by November 18th.
एक ही मनोज क्या है? उसमें क्यों आया? Which document? Affidavit in opposition?
No, my lord, I am relying on my application now. There are 2 letters where I have called upon them. One is for taking inspection of my documents, and the other one saying that I have offered inspection, you have not taken, neither have you given inspection. Pages 11 and 14, my lord.
Correct.
Now, my lord, in their affidavit in opposition, which they have served upon us, which is by the defendant number 1, the defendant number 2 has not.
What?
It has been affirmed today, my
What?
The affidavit in opposition, my lord, as well as the petition.
Affidavit in opposition?
But they have not served us a copy as well.
My lord, I would serve it.
You are appearing for?
My lord, I have the affidavit in opposition was affirmed today.
On behalf of?
The defendant number 2, my lord,
Which is the state of West Bengal.
I can serve it here and now.
No, I'm not willing to accept it unless the court extends it. Now, my lord, in the affidavit in opposition filed by the defendant number 1, which is the West Bengal Industrial Development Corporation, the defendant number 1, Lord will kindly see their explanation as to why they have not provided inspection. Paragraph 4. At E, page 3, my lord. Thereafter, the plaintiff, without taking steps for inspection, discovery and inspection, preferred an application along with master summons taken out on 10th May 2023. Your lordship's order for discovery inspection, everything is in 2024. The initial order is of 23, 27 September is of 24. I wish to refer and rely upon a copy of GA4 at the time of hearing if necessary. I say the defendant number 1 has contested the application, was finally allowed in favor of the plaintiff by an order of 25th of June 24. I crave leave to refer and rely upon the same. I say that it is the plaintiff who has delayed the suit by applying for disclosure of additional documents almost after 2 years from receiving a copy of the written statement. I say that therefore it is admitted position the plaintiff has delayed the hearing of the suit.
When you file the document,
Well, we have already filed it sometime in November.
why you're not disclosed along with the plaint?
No, it was not disclosed because, my lord, the suit was filed when there was COVID, my lord. The records of the company, we had given a tabulation of all the documents based on which, my lord, I had a computed damages. Those records were not available because they were in a district where
Have you taken the leave from?
Yes, my lord.
When it was allowed?
My lord, I'll just give the date, my lord. 25th of June 2024.
June 2024.
Yes, my lord.
And when the copy was served to other side?
Well, I'll just give the date.
June 2024, na?
Yes, my lord.
Yes. So, and this court passed an order on August, 13th August.
By then, we had already given. I'll just indicate when we have served. I have the correspondence file here. When we had served the other documents.
So 18th August, when this court has passed an order,
We had
by that
already
time,
disclosed.
Have you disclosed?
Yes.
So when you
I'll
are
just
disclosed,
indicate when the original order was passed. I'm sure I had disclosed it. না অরিন্দম মুখার্জির অর্ডারটা কবে তার না ডিসক্লোজ কবে করেছি No, I must have disclosed. I'll indicate why. Lord, 27th, if your lordship is pleased to take up the order of 27th of
27th September.
Yes, my lord.
18th, first the 13th August, then 27th
Yes, my
September.
lord. Well, by then we had disclosed. I'll just give your lordship the date. Just find out the date.
Yes, 27th September.
Yes, my lord.
Counsel for the plaintiff has filed the affidavit of document after serving the
Yes,
copy
my
to
lord.
the land counsel.
So because
September.
I had filed the affidavit of documents,
Correct. So
will
you
include all the documents.
So
as
you
well.
have supplied on 27th of September.
Yes, my lord.
Correct. After the 27th September, on 27th September, this court has directed to complete the discovery inspection within 2 weeks after puja vacation.
Yes, my lord.
And made the prep then. So after this 27th September, what has happened?
But there was one more extension taken from your lordship.
3rd December.
Yes, my lord. 3rd December. Then again on 17th December.
3rd December. Then 17th December. And when you file this present application?
This is in January, my lord.
January.
I think last week of December.
Yes.
In fact, November.
No, 3rd December.
3rd December.
You filed it. Yes. Why you are not disclosed, madam?
Your lordship,
Why you are not complete the inspection?
we've completed the inspection.
When?
They have
lordship.
inspected my documents, but not offered inspection of their documents.
We filed an admission and denial as well. The documents that we seek to rely on, they're not in our possession. They're in possession of third parties. We are trying to locate and produce the documents. So we need some time to get. Yes. So we need some time to get those documents. They had a lot of time to get those documents and produce them.
When you got the all documents? Have you got all the documents?
We are in the process of locating and.
Still?
Yes, we have gotten a couple of them. Sorry, some of them.
Have you filed the written statement?
Yes.
How you can file? Your commercial suit?
Yes, my lord.
Your lordship, they also have taken 2 years to file it.
That correct. That chapter is over by the order dated 27 September 2023, 2024.
Yes,
Subsequently, there is a direction If you're telling me when you file the written statement.
24th of 2021, 24th of August 2021, we filed the
2021 you file the written statement.
written statements 2021.
So
Yes.
then
Your Lordship, we
what is the
based our
duty if you
case.
wanted to disclose the new document?
Your Lordship, we based our case on the averments made in the plaint, and these are all third-party documents, secondly. So we need to get those documents because they also relied on additional documents. So we need to make out our defense depending on the documents that they've disclosed. So we need some additional time so that we can produce these documents.
Come ready. When you will be ready?
So a week, Your Lordship, a week.
Within a week. Come ready. Come ready.
Millard, difficulty is this, Millard. I'll just Millard. Millard, my learned friend's prayer is for Millard striking out of defense. Now, Millard, I have been not able to find out that under the Commercial Courts Act, Millard, this inspection and discovery, this concept of inspection and discovery, which is there in original suits, Millard, under the original, that has been done away with. Because now, Millard, the Commercial Courts Act, in order to expedite, Millard had cut short that process and has said that you have to discover documents at the time of filing of pleadings.
That's why all the documents will be filed.
Now, there are two exceptions to it. So far as the plaintiff is concerned, Millard, if he is unable, Millard, he has to satisfy only one query to the court that the leave of the court is necessary because he was not in possession of the documents. So far as the defendant is concerned, Millard, the defendant has three objectives, Millard. One, he can hold documents to confront. The other, Millard, he can come to documents which is necessary for the purpose of dealing with the case of the plaintiff. Here, Millard, what had happened, Millard, when the plaintiff initially filed the suit in 2021, he did not disclose any documents. So far as those documents, Millard, they were only charts and tabulations. So we filed a written statement, leaving it because it's a claim for damages, so it's the plaintiff who has to prove. Now, after 2 years, Millard, he comes up with a whole bunch of documents, and Millard says that these are the documents I want to produce right now in support of my statements made in the plaint. Millard, we opposed, and Millard, the court has passed an order saying that discovery inspection provision in the CPC will not apply. And the court was satisfied that they should be given an opportunity to lead their case. That, Millard, got over only, Millard, in June 2024. Now, Millard, he has given me a bunch. I am a government department, Millard. Now I have to meet those documents. Initially, if he had gone with the plaint, I don't need to disclose any documents. But now that he has come with affidavit after 2 years, he wants my defense to be stuck out within a month because I am getting delayed. Now, Millard, this, Millard, with the utmost respect.
So where your document is ready?
No, Millard, my difficulty is this, Millard. This pertains to, Millard, that dispute in Shingu, Millard, where Millard claim is for damages for they not being.
Shingur has gone to the Gurgaon.
I know that. But the thing is this, Millard, since it has got to the Gurgaon, now I'll have to retrace those 15 years old back documents. And being a government concern, Millard, I'm working for the first time. Everybody passes the buck. For this, you need to contact that department. For this, that's why, Millard, I've added a line that these administrative difficulties, Millard, are coming in the way. So far as this application, Millard, I can contest it that there is no provision.
Leaving aside the but the suit is because
I
it's a
have to.
commercial suit.
Yes.
The commercial suit, the timeline needs to be fixed. Already the court has fixed the timeline by the September dates and December
I know that,
2
Millard. I mean,
Two
I'm
dates
in fault of that. I'm not arguing that. But give me some reasonable time because
and you have not come with an application for disclosing further
no,
documents.
that is when because Millard, if I make an application, then your lordship will give me leave to file it. But I need to have that bunch because otherwise I can't file an application, say and give.
Correct, that's correct.
So what I have advised, get your documents ready, take leave of the court, give your reasons why you could not do it, and file it. And for that, Millard, I'm stuck because I have parted with instructions, but the documents are not coming.
The otherwise,
Documents are there.
If the documents are there, when you get to let the should be proceeded.
Yes, but the thing is this, Millard, I had also apprehended this would come from the court. But the thing is this, Millard, once he starts his evidence, now it's an evidence stage. Once he starts his evidence, without getting Millard a feel of what are my documents,
Now, what I propose to do,
my lord,
this application I am keeping pending. Now I am not disposing as of now.
my lord.
I am directing to exchange the suggested issues.
I've already filed.
Yes, right. Suggested issue. I am fixing up to 2 weeks or 3 weeks. for framing of issues.
My lord.
Correct. Let the issue be framed. In the meantime, you are getting, you take
Yes,
appropriate
yes,
step.
Milord.
If you
I
not,
think, Milord, 3 weeks is more than it.
if you will not get the
No,
particular proceeding,
Admission denial is
no affidavit of
extension.
admission and denial.
Extension.
only in respect of discovery of my documents.
No.
Give the copy to.
Extension doesn't need extension.
So and so appearing for the plaintiff. So and so appearing for the defendant number 1 and so and so appearing for the defendant number 2. The plaintiff has filed an application being GA Com 5 of 2024, praying for striking of the defense of the defendants on the ground that the defendants have not completed, not disclosed their document for inspection, in spite of several orders passed by this court.
Has to be. Absolutely.
Learned counsel for the defendant number 1. Mr. Dutt, you are for the 1. Defendant number 1 submit that the document is still not traceable and the department is in search of the documents, and as such the defendant is not in a position to take appropriate steps to disclose their document. Full stop. The counsel for the defendant number 2 has filed the affidavit of admission and denial of document after serving the copy to the learned counsel for the plaintiff. Let the same be kept with the record.
I have filed the affidavit.
Affidavit?
Well, that's the extension Miller I'm opposing. They had taken whatever time they wanted to.
The defendant number 2 also filed affidavit in opposition to the GA Com 5 of 2024 after serving the copy to the learned counsel for the plaintiff. Let the same be kept with the record. The plaintiff has a liberty to file reply, if any, within a week thereafter.
Well, let them serve. We have not been served.
Full stop. In full stop. This court finds that the defendant number 1 is still in search of the document which the defendant intend to rely upon. And as such, for the said purpose, the suit cannot be stalled. Accordingly, the parties are accordingly, in the meantime, the parties are directed to exchange the suggested issues, though the plaintiff has already filed the suggested issues. Full stop. Let the matter appear on 7th of February 2025 for framing of issues.
Grateful. I have filed the suggested issues, my lordship. The same will be kept on record. Grateful.
No. 2 crores or 200 crores is not. No. My problem is, Milord, the department passes on the part. That's the whole problem. Somebody comes for a conference, then says you have to.
The court, 2 courts after your lordship's court, 129 crores of the state has been attached already. Today.
So he knows that there is nothing left. Why is he pursuing?
The Bank of India was only depleting state's money.
Whatever he.
Yes. Thank you.
Grateful.
Right. Dispute nahi kiya.
Your lordship, before your lordship takes up the
666 matter. Yes. Item number?
My lord, we'll take the bunch of cases. My lord, I was dealing with the stamp aspect. For any purpose, if it is unstamped, it cannot be relied upon. I showed you the section. I showed you a case on that. My lord, even for collateral purpose, it cannot be relied upon. Then, my lord, the next judgment in the line is, my lord, the judgment of the Supreme Court of Justice Dipankar, presided by Justice Dipankar Gupta. Dipankar Datta.
I will save this.
My lord, your lordship, I have heard, it's not gets recorded in YouTube. My lord, he incidentally was my first senior. So.
Yes, with judgment.
My lord, the name of the judgment, my lord, is this 2024 7 SCC. Please. My lord, it is running page, my lord, 45.
Yes.
Has your lordship got this? Yes. Why am I citing this judgment? My lord, I am citing this judgment to show, just in case they say, my lord, those are unstamped, unregistered documents, but for the purpose of the interlocutory application, my lord, I annex those documents to show how did you, he will ask, how did you come, become a tenant? So I annex the document. I've clarified it in paragraph 4 and 5 of the chapter 13A that these are unstamped, inadmissible, cannot be relied, yet I annexed it. Now the point which I am urging in this, my lord, no matter of consent, even if I agree, will make a
Law does not permit.
law does not permit. You cannot make an unstamped, which is unstamped, may not go into evidence. You cannot rely on. That's the no manner of consent.
Yes.
That is why I am relying upon. Yes. My lord, will your lordship blindly come to paragraph 14, 15? My lord, I just the relevant paragraphs. It's all in my note. My lord, I've done it. My lord, paragraph 14, 15.
Yes.
Mr. Chaturvedi, learned counsel for the appellant, while laying a challenge to the impugned order, argued that admission of an insufficiently stamped in a casual manner by mechanically marking it as exhibit without any application of judicial mind should not preclude court seized of the proceeding from considering whether sufficient could have been admitted in evidence. This was the argument. My lord, next paragraph, Mr. Guru, learned counsel, defended the impugned order by asserting that it is correct both in law and in fact. It was argued that setting aside of the trial court's order by the impugned order was indeed justified, since, my lord, the general power of attorney, having been admitted, such admission could not have been reviewed by the same court under any circumstances. My lord, objection was the need for an objection to be placed on the admission. So here, my lord, there was also not objection raised when it was being tendered. So what the learned judge later on realized that I have done a mistake and recalled his order. Carried up to the division bench, how could the learned judge, once passing an order, an admitted document be recalled? My lord, the division bench says, yes, you're right, set aside. Supreme Court said, no. My lord, kindly see para 17. Despite the general power of attorney, my lord, having been admitted in evidence and marked and without objection from the other side, we propose to hold for the reasons to follow that trial court did have the authority to revisit and recall the process of admission and marking the instrument not in sense of exercising a power of review under such and such. That's the only remedy. Kindly straight away come to paragraph 21. The presiding officer of a court, being authorized in law to receive instrument, is bound to give effect to the mandate of 33 and 34 and retains to impound even in the absence of parties. Such an absence of objection would not clothe the presiding officer of court with power to mechanically admit a document and is tendered in evidence. The same limitation would arise even in case of an objection regarding admissibility owing to insufficient being raised before, very important, irrespective of whether objection is raised, question is to be decided in accordance with law. My lord, kindly come. My lord, and the division bench is saying, Supreme Court is saying para 25. But it is also very important in other cases which your lordship now hearing. Very important, my lord. I thought I will draw your lordship's attention, my lord, to
Thank you
2024. My lord, I also, in fact, I'm arguing something, my lord, in Justice Sugata Mojumdar's case, the same point. And so, and apparently Justice Mojumdar told me there is another case, Sonu's case. Where this, and I followed it up and I found my junior gave me this case. I said, wow. My lord, para 25. It is here we need to rationale behind court's approach to go behind general power of attorney in evidence, marking it as an exhibit, leading the order of challenge to the High Court. Well, straight away, next page. And the one in italics.
Page 25, para 25.
Well, it's, yes, para 25, yes.
The pivotal
Yes.
aspect of the emerging.
Yes, a challenge before the last few lines, challenge before the Honorable Court. Miller and sets out next para relevant portions of the trial court order. Miller, kindly next page. I am reading, and this is the law on the subject. Miller trial court, whoever I don't know. Miller, next page in italics, para 10. The circumstances under which the application is filed, under which came to be marked, clearly show document was marked without application of mind of the court, without objection on the other side, and this court is of the view could be considered at this stage. This was the view of the learned single judge. Millard, this is recorded in the order. Now, Millard, kindly come to then para 30 and 31 will set out why it is essential. I'm not reading anything else, Millard.
Yes.
We may not turn a blind eye to the fact revenue would stand to huge loss if courts fail to discharge the duty placed upon it under section. Such provision has been inserted with a definite. Legislature has enforced responsibility on courts and entrusted to requisite stamp, etc. If duly paid or insufficiently for admission, it is incumbent upon court to uphold sanctity of legal framework as crucial for authenticity and enforceability of instrument, allowing it to be insufficient to pass merely due to technicalities would undermine legislative intent and fiscal interest of the state, etc., etc. And Millard, para 31 says, I find no error in the order of trial court dated. We set aside the order of the division bench of the High Court. Millard, next point. Now, okay, Millard, so it's the first hurdle. Millard, you get over the hurdle of stamp. Now comes the hurdle of registration. The same thing. I want to show you cases on registration. Millard, it is compulsorily registrable more than 1 year. That is why I cite. Now, Millard, there are cases when at times you will find that the document may be unstamped, but it does not require registration, like it's 11 months less. 11 months less. First, you get the hurdle of the stamp. Very well, you get the hurdle, you impound it, and then still you cannot rely upon in my case, because it is not registered. So now if they say, I want to now impound, and you send it for impounding, but nothing will help, because the second chapter, the registration aspect will fall over there. Now, Millard, kindly see page next judgment is, I think, Bajaj Auto.
Yes.
Has your lordship found it? Yes.
Yes.
Millard, this is a very interesting case. Millard, I am citing this judgment clearly that Millard, and the aspect of Registration Act. Millard, Registration Act has some distinction from the Stamp Act. Remember, Millard, Stamp Act said for no other purpose.
Only for collateral, yes.
No, that does not is mentioned. Not Millard, in Stamp Act does not mention collateral. For any purpose, it can't be relied. But the Registration Act, Millard, in section 49 says that, Millard, and I'm reading it out for your, it's set out. So, Millard, I'm stopping. So I'm not reading it out. Section 49. It says as collateral evidence. In certain circumstances, it can. So this collateral thing, which your lordship is, which we always see, is in the context, Millard, of Registration Act. Now, for the Stamp Act, I have already shown you a judgment that even for collateral purpose, it cannot be relied upon, essential. That is a separate aspect. Now, this one is interesting, Millard. Here, Millard, para, Millard, so 4 is important. Millard, please look at this, what happens, the effect. The eviction proceeding was defended. No, this is Bajaj Auto. Was defended by the appellant on the ground that United Automobiles are authorized dealer, distributor, and has been in occupation in the capacity and cannot therefore be described as subtenant, because this is a ground for eviction. On the ground you have been subtenant. Now, my lord, a few lines down, the stand of the respondent has been that the aforementioned term of the lease cannot be looked into, as the document was not registered, and further, United cannot be assumed to be associate. The rent controller, as well as the appellate authority, held that the aforesaid term of the lease was not admissible, and the appellants were entitled to rely upon the same were entitled to rely upon the but ordered eviction on the ground that United was inducted as a subtenant. Now, then the special leave is filed. It has been strenuously argued in small I, United is distributor of product manufactured on the basis of commission. It pays the same amount of rent as payable by the respondent and is entitled to be in possession only as long as it continues to be a distributor. It should be held to be an associate within the meaning of the term of the lease. It's a term of the lease. In reply, respondent's contention that term cannot be taken into consideration as the deed is not registered one. So whether it's perpetual, whether you cannot do this, you can't look at it. It was argued in view of the provisions of 49 is entitled to rely collateral purpose, because I'll show you section 49, what it says, and that explanation has been given, my lord, in this. That is why I wanted to show you this judgment. The arguments is that the documents may not be admissible for the purpose, but as the aforesaid mentioned, does not come within the category. Then, my lord, para 6, last few lines. My lord, the dealer, has your lordship found?
Yes.
The dealer pays a fixed sum as rent to the appellant, and rent is not related or dependent on the sale of any vehicle. The fact that this amount is the same as is paid to the appellant to the respondent does not appear to be material. The irresistible conclusion is that appellant has created a sublease in favor of the dealer. The question now is whether the clause in the lease mentioned above amounts to the respondent's consent in writing or not. Then the contention of learned counsel is that the aforesaid clause cannot be looked into appears to be correct. Reliance has been placed on, this Ramjas Agarwal is important, that if a decree purporting to create a lease is inadmissible in evidence for want of registration, none of the terms can be admitted in evidence, and that to use a document for the purpose of proving an important clause is not using it for collateral. You cannot say that I'm using it for collateral. So this is a definition, watering down the wording of collateral purpose, because the section, if your lordship wants to, because it will take time, I'll just give it to your lordship. That's provided in the proviso to section 49. Collateral purpose is also not used. It's very restrictive. It's collateral evidence in other transactions. Just have a look, the proviso, my lord. This is the language.
Or the evidence any collateral transaction not required to be.
Yes, collateral purpose is invention of courts.
Or as evidence of any collateral transaction not required to be affected by the registry.
Right. Collateral transaction, collateral purpose is our invention.
Yes.
Invention, we are using it as collateral because courts have stated. Registration Act does not say this. And for the purpose of specific relief. You file another suit and some document. Yes, probably. That is what I wanted to. So this court, defines what court. None of the terms you can look into as for collateral purpose. That is why I gave you this registration. My lord, next judgment, KB Shah from our court, happens to be, my lord, those is everything from our court. I'll show you on the side. More clear. Justice Chatterjee's judgment, I believe. Justice Torun Chatterjee. Millard, you got KB Shah, yes. So you please come to Millard, paragraph 23. That is why I didn't want to show you the book. It is set out. Millard, have you found that? Paragraph 23 of the judgment?
Yes.
Millard, the another section which is material is section 49.
Yes.
Millard, may I just, since I didn't have the occasion, provided that unregistered affecting immovable property required to be registered, my lord, it says may be received as evidence of a contract where in a suit for specific performance under chapter 2 or as evidence of a collateral transaction not required to be effected by registered instrument. This is a section where do you find any collateral purpose mentioned? No, but it's invention of our court. My lord, we have taken collateral transaction as a collateral purpose. My lord, and defined it in that case, my lord. My lord, I show you, yes. Now, my lord, kindly see next paragraph is basically say that we do not find interference with the High Court judgment. My lord, section para 27 is important. My lord, in the context of 107, it is saying.
Yes.
Section 49 clearly provides that an instrument purporting to be a lease and required to be registered under section 107 will not be registered in evidence if the same is not registered.
Admissible, yes.
Yes. Proviso, however, provides the may be looked into for collateral facts. Transaction. No, evidence of collateral, not facts. Transaction.
Facts.
Mr. Manad, yes.
May be looked into as evidence of collateral facts.
Facts. What is transaction? Whatever it is. Manad. Mr. Mukherjee learned counsel argued tenancy in question was exclusively granted for the benefit of a named officer and his family, and unless landlord, no person could use it for any condition. Now, para 29.
Yes.
As we have noted, under proviso to section 49 registration, an unregistered document can also be admitted for the purpose of collateral transaction. Let us know meaning of collateral to ascertain whether clause 9 can be looked into for whether that named officer can be looked into or not. Clear answer, posing the question. Para 31. The court in the impugned judgment relied upon Allahabad High Court in such and such to hold that since appellant, this is important, wanted to extinguish right of the respondent with the help of an unregistered tenancy. And this observation in Ratan Lal's case discussing the mean of collateral purpose, it set out the second contention was that partition deed, even if it is not, would certainly be looked for collateral purpose, used for the purpose of saying deed created or declared, assigned or extinguished a property. Term collateral would not permit the party to establish any of these acts from the deed. No term of the deed you can look into.
Cannot be used for the purpose of saying that the deed created and declared or assigned or limited,
yes,
extinguished.
for the purpose of this partition deed. We are talking about lease. That's there. But it says term collateral would not permit the party to establish any of these acts from the deed.
Correct.
No term can be looked into. And more clear, the whole guideline is set out in para 34. My lord, if you just see the para, and over the years, people have been quoting this paragraph, paragraph 34. My lord, I rely only on the guideline 5 in para 34. My lord, first is, of course, document registered is not registered, but 5 is, if the document is inadmissible in evidence for want of registration, none of the terms can be admitted, and the use of a document for the purpose of proving an important clause would be using it for collateral purpose. My lord,
Not be using as.
would
Not.
for the purpose would not
Would
be
not.
using it. Sorry, yes, it's a negative way. Would not be using it for collateral purpose. So you can't rely on that proviso. My lord, same thing. My lord, para 35. In our view, the particular clause agreement in question cannot be called into as a collateral purpose. So clause 9. Well, I'm not reading. My lord, your lordship. My lord, the principles of law. My lord, I've said yes. Now, my lord, the next case is McDonald's case. Milord, as you, Park Street proper, are you aware, Milord, of McDonald's? There was a Blue Fox.
Yes, yes, yes.
Blue Fox, Milord. There was a big fire. After that, Milord,
Finish.
many times we have gone. Milord. Park Street versus
Deepak Kumar.
Milord, an ingenious argument came from our court, Mr. Anindo Mitro, and I will show you. This was I'll tell you the argument. Milord, say, Milord, I look at the judgment which is negated. He was appearing with Mr. Gopal Subramaniam, and here, of course, for Park Street, Mr. Sundaram was appearing. But note the argument. It is something different. It is something different and worth considering. But it's been negated. That's neither here nor there. My lord, kindly come to para 2. Para 2, my lord, about 8 lines down or 10 lines down. In pursuance to the same, agreement was terminated and tenancy was created on the basis of an unregistered document. Has your lordship found? There was an unregistered document. Has your lordship found that portion? Yes. Then, my lord, para 3, first line, there was a 106 notice.
Correct.
Then para 4, the respondents contested the suit that necessary implication, the agreed not to terminate before 30 years, and that is why the clause for incorporated, etc., etc. This was the argument. Now, my lord, para 5, the trial court held 5 lines. When the document is inadmissible, none of the terms can be admitted as evidence. My lord, which I showed you, and clause 6 is an important term of the lease, which we cannot rely upon. This is relying on KB Shah and all this. It was held. I think it is by Justice Sen again. By Justice, I think so. I am not sure, my lord. Then, my lord, straight away, the argument, I wanted to show you the argument which was advanced. Completely different, which you will not find in any other case, but worth considering. Something new and novel. That's why I wanted to. My lord, kindly see para 10.
Whether that was accepted?
No, not accepted. But my lord, to think. My lord, we always think. But to say this, and I'm my lord, para 10. Para 10, that KB Shah is set out. My lord, I showed you KB Shah, that a guideline 5 is important. Now, my lord, para 12 is the argument. My lord, just slowly let us, my lord. On the other hand, then it counts, senior counsel appearing, content, my lord, please note this, termination lease is by definition to disrupt a contract between the parties. Section, this is important, 106 and 7 provide for duration how they are made. It is submitted that section 106 cannot be departed from, and that operation cannot be excluded by virtue of can be excluded by virtue of 106, my lord, only in cases when there is a valid contract to that effect, because to the section 106, unless there is a contract to the contrary. No one decided this. But yes, 107 is there, so 107 will not apply because we have a contract to the contrary, 106. My lord, I didn't find it anywhere argue this point. Then para 14, 15. Learned senior counsel contains 106 need to be adhered to as clause 6 operates as contract to the contrary. Then we have heard appearing on behalf, essential question for us is whether the agreement can be heard in evidence, whether it's a contract in terms of 106. Now, Millard, kindly come to para 17 after the italic portion. Thus, in terms of clause 6, landlord is entitled to terminate in case of breach, etc., etc. The aforesaid clause of the contract is clearly contract contrary to provisions, but while 106 does not contain phrase in the absence, it is well positioned as meant by there must be of some effect. It is also well settled that in the absence of registered instrument, courts are not precluded from determining factum of tenancy from other evidence from conduct of parties. Accept it. You can say that there is a tenancy. Then, my lord, kindly come to next page after italic portion.
Paragraph?
My lord, that paragraph, continuation of paragraph 19. Yes. 19. My lord, saying, thus, I'm not reading all this, my lord, it's all some case. Thus, in the absence of registration, what is deemed to be created is month to termination is governed by 106. This is exactly what I am saying.
Thus, the absence of registration of
document to be created is a month-to-month tenancy. This is what, my lord. And then it says in para 20, fourth line, while the agreement can be admitted in evidence, even relied upon to prove factum of tenancy. Factum of tenancy. Evidence, factum of tenancy, the terms cannot be used to derogate from statutory provisions of 106. So whether it's perpetual, it is a monthly tenancy, right? Which creates a fiction of in the absence of registered. If the argument advanced by the respondent is taken too logical, this lease can never be terminated, save and except for breach of tenant. Accepting this argument would mean in a situation where there does not default payment of consecutive, it does not commit breach. It is not open to the lessor to terminate lessor even after giving notice. This interpretation cannot be permitted as the same is wholly contrary to the express provisions of law.
So you mean to say the argument made by Mr. Saka?
That is contrary to law, and that will be my answer to the case which he has cited. So it's contrary to law, the phrase, then it explains what is meaning. Contract in section cannot be read to mean parties are free to contract out of the express provisions of law, thereby defeating the very intent. So for no purpose you can rely on the term of a particular document. It is a monthly tenancy by fiction, by operation of statute. And that is what, Now, then comes the next judgment. Then it all becomes easy. Supreme Court, Division Bench, Paul Rubber. Here it was a manufacturing lease. Clause said it is for manufacturing purpose. Yes. Mr. Aniruddha Chatterjee said because it is manufacturing purpose, then this does not apply, etc., etc. Mr. Joyanta Mitra said, no, you can't look at the lease. Whether it's for manufacturing, you can't even look at the lease. Kindly see next case to this particular case online. Paul Rubber. Has you got Paul Rubber? My lord, Paul Rubber. Yes. My lord, kindly see the said judgment, first paragraph. Judgment was challenged that the lease was for manufacturing and there it was terminable only by 6 months notice. That is the section, my lord, 106 says if it's manufacturing, 6 months notice. My lord, here it was no 6 months, so gone. My lord. Para 4, there is no dispute that it was put into possession by virtue of an agreement for 5 years for manufacturing. Then, my lord, para 5, third line, tenancy shows unregistered agreement. Para 8, my lord, third line, appellant has admitted the fact that in the plaint and in the plaint has been relied upon in the plaint in support of the claim. Then, my lord, para 12, Mr. Chad submits that having regard to the fact that plaint has admitted was for manufacturing, there is no requirement to adduce any further evidence. My lord, wrong pleading in the plaint that it's for manufacturing. So you don't have to look. Someone did the big mistake of not reading 106 and included in the plaint. Now, my lord, say, Mr. Chad submits admittedly was for manufacturing, falling short 106 as required by said even the date of filing taken into consideration. My lord, then straight away, para 18. Learned senior counsel submits in the absence of any register between the parties, lease cannot be looked into, said would be treated as a lease month to determine by notice of 15 days. As your lordship found, this was the argument. Well, not obviously upheld. Para 23. First, we discuss the effect of unregistered lease agreement and all these sections which I've been arguing so far. In para 24, 106, etc., etc. Then straight away come to para 27. The effect of non-registration is admissible in evidence. Section provides that movable property for 1 year. Then section 49 is set out, section 49.
Yes.
Then 30, unregistered is in place for collateral. Essential terms, essential cannot be treated as for collateral purpose. Just what I've been saying. The recitals cannot be used. Then all this para 30, para 37, Park Street properties has been relied upon. I'm not, then para 48 and 49, the decree is upheld. And because they were defaulters of paying prior to the notice, money was, I have not claimed, I have not claimed anything in my chapter 13A. So, the only thing, if your lordship is in my favor, is summary decree with direction of commissioner to appoint mean profits with a proviso here, because they are not in possession of the entirety. They can't give vacant. That is why the interlocutory application comes. They were in only possession of the third floor. The rest of it is sublet to different. For that eviction, I have to do in accordance with to evict them, throwing out. You can't because they are not parties. That's a subtenancy which has been created.
They are subtenant. You have not made the subtenants as a
no, because they are subtenants in accordance with it can't be done. It can't be. Mine is 106 only vis-a-vis him. The tenancy is governed by.
So you are
that is
that if the 13, if suppose this is allowed, then you will take appropriate.
Yes, of course. In accordance, if I want to, I am the landlord. Then say this is what has happened. This is how it happens, my lord. Because if I try to evict, they are protected by the rent control legislation. Those against vis-a-vis him. So I have to take my steps.
Okay.
Of course, my lord, I cannot throw out a genuine, evict. My lord, the decree has to be implemented. All these questions will arise in execution. But that is why, my lord, I wanted to. this case, the last case in the list, my junior has given to me because he was scared, my lord, that in the event your lordship says, no, there are two tenancies, so there is misjoinder of cause of action. So I said, we have treated it as consolidated tenancy, so we can't change our case. But he said, even if you treat those as different tenancies, then even then the rent for both them is over 10,000. And therefore, my lord, I have issued one combined, so it does not matter. They are not governed by rent control legislation. And my lord, this point apparently was argued in some matter, page, my lord, internal page 2. He further submits, second paragraph, have you found? He further, defendant is occupying two different tenancies arose from two different contracts clubbing.
Where?
My lord, internal page 2, my lord, 113, my lord, middle. He further submits defendant is occupying two different tenancies arose from two different contracts clubbing two different tenancies in accordance in single unit not permissible for moindature. Then learned counsel says matter of ejectment of the same jointly of two in one suit is legally permissible. Same cannot be dismissed for misjoinder of parties. My lord, kindly come to my lord, running page. Third last page. My lord, on yes, running page 116. My lord, on perusal of the schedule of the plaint, it appears to internal page 5. Running perusal, it appears two are mentioned in A and B. My lord, so two tenancies. Here, of course, there is one. In our case, there is one, but that they want to split it up. So 125. Sorry, 110. Next page, internal page 6. Here in the present case, right to relief is in same series of transaction. Then, my lord, next paragraph, category has said 106 notice, etc., etc. And my lord, it's a revision application. So, my lord, no, nothing bad for misjoinder of parties. My lord, here, if so, he wants to say, my lord, my junior, that even if you hold two separate tenancies, both are above 10,000. In the same building.
But here only the court has
My lord,
decided
strictly that's
with regard to the section 80 notice.
Yes. My lord, no, 106 only.
106 of the Trust Property Act, the defendant terminating this.
Yes.
Under section 80 also sent to the.
Yes. But 106 was also there.
But the court has decided with regard to this.
Yes, I find no merit in the
cause of action has not decided.
Yes. My lord, page 6, internal page 5. My lord, sorry, internal page 6. So far as the issue of defectiveness of notice, it appears para has categorically stated that it is notice under in respect of the so the 106. Then it says in the facts of defectiveness notice is a question for you, etc., etc. In view, I find no merit in the revisional is dismissed. He wanted to show it to the said that look here, even if it is above two tenancies, both are more than 10,000 rupees. So even then it is covered. That's what he wanted to. But my case is not that. My case is it's a combined. And I showed you judgment. Now, my lord, I have to distinguish the cases. Yes. Now, my lord, quickly, may I first deal with the first case, Justice, I think, Ajaynath. No, Justice Bhaskar Bhattacharya.
Justice Bhaskar Bhattacharya, Food
Yes.
Corporation of India.
Yes. My lord, the
fair rent.
Yes. Fair rent that only here
be fixed by the rent control.
My lord, parties prior to filing the litigation have agreed. I am not asking your lordship to decide fair rent. Simple. Parties have agreed prior to approaching your lordship. This is how I distinguish. My lord, for that you may note paragraphs 1, 4, 5, 7, 6, 19.
1, 4, 5, 6?
Yes. para 1.
1456.
Oh, sorry. My lord, 1457, 1619.
1619.
He relied on 18.
Yes,
I'll tell you why. Why? My lord, in last line of para 1, it says, my lord, kindly see what was the order. Is at the instance directed an order. Huh? আরে তোমরাই তো দিয়েছো।
2006 SCC online Calcutta 417.
2007 1
Food Corporation of India.
Yes. Now, my lord, kindly the last portion of the line, directing zonal manager, this was in the right of observations of the order. So a writ petition was filed. My lord, very important, my lord. Then para 4.
Release the sum of rupees.
Yes.
Read for
My lord,
direction
being
to
satisfied, preferred another writ petition. Has your lordship found? So 2 writ petitions. One, he's dissatisfied. Next is he's dissatisfied and files this writ petition.
Yeah.
And it is in this context, my lord. Then, my lord, kindly come to 5. The aforesaid was opposed, etc., etc. So, my lord, what his lordship was taking in the division bench was an appeal from an order passed in a writ petition. Then, my lord, kindly come to 7. What is the argument? That provisions such and such are there, and the zonal manager cannot be directed to judge the fair rent. Manad has
yes.
Yes. They go through the rent controller.
It is the exclusive domain of the rent.
Correct. That is in that context.
Correct.
Then, my lord, paragraph 16. Question is whether writ court can permit landlord to writ court. That is, my lord, am I asking your lordship that the to determine to determine? I am saying this is done by the parties. Then, my lord, 19. From our, it is clear that registration has permitted, etc., etc. My lord, then even if there was agreement prior to the tenant is not bound by agreement, etc., etc., has to approach rent controller. Now, my lord, the nicest thing is, my lord, remember this is the second writ petition. But the first writ petition,
direction,
he had already fixed rent. Matter came, new writ petition, even that was not being paid.
Correct.
Came before Justice Sanjeev Banerjee, another writ petition. Now, my lord, and this is the order, same matter, said you certainly, very well, I am bound by the order. My lord, my lord, I will give him the case. As he has not brought it. And my lord, reported, my lord, in our usual fairness, no copy is being given to the other side. Now, my lord, what can I do? No, তোমায় দেবো, তুমি দাঁড়াও, correct. Correct. My lord, you see that order directed the writ petition said, you may have lost in this second round. The first one remains. First one, my lord, first one was.
This is a first petition.
The first writ petition was there. It directed the zonal manager. Zonal manager fixed.
Correct.
Then the second writ petition was filed.
Is not the proper.
So what happened to the earlier fixing? That also you won't give. No, give. So Justice Banerjee, no, that is supposed to be given. My lord, if you test it that way,
in the event upon the second petition ultimately failing, the plaintiff could not be worse.
Yes.
Of then when they are instituted such second petition.
Yes. So maybe I have
Pay
lost.
the petitioner 5 rupees so with the decision of the zonal manager
Yes,
of higher institution.
my lord, because the first writ petition says zonal manager, you decide. Zonal manager decided. Then the second writ petition, I am aggrieved by this. That is Justice Bhattacharya's judgment from appeal from that. But the first one remained. So just my lord, here also writ court directed zonal manager.
Yes.
Does it matter? I mean, we are often filing that please consider.
Okay.
Statutory body will now, my lord, Justice Swatantra Kumar's judgment, my lord, on that TDS, effect of TDS. Bombay High Court.
Yes.
My lord, before I show this, this was under Order 7, Order 37.
Order 30.
Just have a look, my lord, Order 37 contempt is a contract. My lord, just have a look, my lord, at Order 37. There are 4 grounds under which Order 37 suits can be filed. Now, just on the basis of TDS, you cannot file any Order 37. This has so been held. That is the only ratio of this decision. My lord, kindly see Order 37.
Yes.
My lord, it is bill of exchange. My lord, then liquidate debt or liquidated demand of money with or in the on arising when out of written contract.
Correct.
Now, guarantee a recovery assignee. Now, my lord, just TDS, where does it fall? Nowhere. My lord, suppose there is only a TDS certificate, and that is the basis of your claim.
Yes.
It does not fall under Order 37. It will only fall under Order 37 if there is a written contract.
Yes.
Now, TDS acknowledgement, may not in writing, can become a written contract because the acknowledgement is a written contract. Now, my lord, division bench, Justice in Bombay High Court holds this, may not. And my lord, may I remind you that TDS I am not relying upon just for the how much money. I am saying 35. You have said you have uploaded it on 194, saying it is rent. Those are things which I am relying on.
That's why you are relying. They are taking it a composite.
Composite.
And paid the TDS.
And as rent.
That's why paid the TDS as a
That
rent.
is why, my lord, that is a separate thing. But still, to answer your lordship's point on this judgment, my lord, paragraph 1, kindly see, my lord, what happened. According to plaintiff, his father's family had good relations. So, Kadakia, partner, approached and took a loan. This loan was paid by check. There was oral agreement between the parties. My lord, has your lordship found?
Yes.
There was oral agreement between the parties.
Yes. And
then, my lord, little down, defendant deducted TDS.
Correct.
So, on the basis of this, and these TDS were the exhibits.
Correct.
And the last line says in paragraph 13, has claim suit has been filed under Order 37. How can you file on the basis of an oral agreement? My lord, has your lordship noted this?
Yes,
this was an oral agreement. Only documents were the TDS.
Yes.
Right, my lord, kindly see para 4.
Yes.
Last 3 lines. It is contended TDS cannot be treated as acknowledgement in writing of debt due. Reliance has been placed on such and such. TDS, if it is acknowledgement in writing, then it becomes a contract. So that is the ratio of the judgment. Then, my lord, then para 6, 3rd line, suit as framed would be maintainable under Order 37, etc. Then, my lord, para 8 says, first and foremost, we have to consider, my lord, this is important, whether the suit covered under Order 37. So this was the question, my lord. And the last line, secondly, this is a question of law. It is obligatory to show from bare reading of the plain suit would be maintainable. The issuance of certificate does not apply. Well, it is in this context it is being said. My lord, has your lordship found? Then, my lord, a little below, the bare reading of Order 37 shows these provisions have been such as a suit based on bill of exchange, liquidated, etc., written contract, but arising from a written contract. My lord, it is not an Order 37 suit. Therefore, it gets dismissed.
Yes.
On the basis of you cannot.
Yes. Any further?
Yes, yes. My lord, though that other case I'm not dealing, that fat judgment of Justice, my lord, everyone, my lord, I think Justice Chandrachud, Justice Kaul, Justice Khanna, Justice Surya Kant, Justice Gawai, and I think Justice Manoj Mishra is also there. My lord, this is on the context of Arbitration Act. Arbitration Act is an independent agreement. It does not require to be stamped, and it is to be decided by the arbitrator. With its answer at the time of Section 8 or Section 11, it need not be stamped. This is the ratio of that judgment.
Yes.
But it is not context in general about Stamp Act. But I have more or less continued everything, completed everything in all applications, except for one thing I must point out. In my chapter 13A, I have prayed for whatever you will find in paragraph 4, in the interlocutory application, you appointed a receiver to show who was in possession of the properties. When the receiver filed a report, you kept the he has filed a report, and the report is there before your lordship. He has been subsequently discharged, and you have injuncted them from selling, disposing, alienating any portion of the property. My humble prayer, whenever your lordship will decide, that injunction should continue, but the report is important. The report says, which I said, I annexed a telegraph, paper showing that the third floor, it's under lock and key, and they have shifted because it says defendant is no longer occupying. If you see the, you can see.
Okay, I will.
I have annexed pictures, they are occupying. And indeed, when the special officer went, he filed a report saying, yes, they are not occupying the third floor, but it is being other floors are being occupied by other people who are claiming to be occupiers. Whether as subtenants or tenants, I do not know. So, third floor, they have shifted. That's what they say. Your lordship can see. So, এগুলো কেন দিয়েছে? এগুলো কপি আছে? Well, he got hold of judgments of Justice Ravi Kishan Kapoor and your lordship, where your lordships have also 106 evicted. This is the latest judgment we could find of Justice Ravi Kapoor. I am not placing this just to show a completeness of the 106. Normal. I have placed Supreme Court and Justice Division Bench. After that, nothing lies. And your lordship, I believe, has in another matter unregistered. You have passed a summary decree in a chapter 13A. First line shows chapter 13A. Just for completeness, and because we are before your lordship.
Yes.
So one judgment. I made submission in all of them, but the notes is relating to chapter 13A only. It covers the side.
Okay. That's all.
May I start, reply? Next.
So-and-so appearing for the plaintiff. So-and-so appearing for the defendant. Plaintiff has concluded his argument. Full stop. Due to
Melody in all matters.
concluded his argument in connection with both application, that is GA3, GA1 and GA3, na?
GA1, 2, 3, 4.
GA1, 2, 3, and 4.
4. 4 tak here.
Extension.
4 is extension. Extension of time to file written statement.
Due to paucity of time, counsel for the defendant could not argue. Accordingly, is adjourned. Accordingly, case is adjourned. Please the matter.
Well, Tuesday subject to my lord convenience.
Tuesday কত তারিখ?
21
नॉन कमर्शियल ना? अच्छा कमर्शियल में टाइम है 21 तारीख. Yes, 21 at 11. 11:30.
Well, an interim order is still 22nd.
22nd. Come on, 21st. 11:30. Yes, next. Mr. Bose, take your book. Yes, next.
Your Lordship takes up the testamentary list. May just be permitted to mention item 10 of your Lordship's today's list. Your Lordship, the affidavit in reply, your Lordship has ordered, has granted us opportunity to affirm the affidavit in reply. We have affirmed it. May we be permitted to file it? I'm grateful. We have also served upon, yes.
Okay.
So may the order be modified accordingly.
Or you do one thing, keep with you.
We shall
File on the,
on the returnable date.
that will be better.
Grateful.
Yes, next.
My lord, there's an order of 23rd of December in this testamentary proceeding. I appear for the propounder of the will, my lord. The executor died during the pendency of the proceeding, so this has to be now converted. It's a testament, it's a TS number given because we contested. Now, my lord's last order of 23rd of December records this. Now, I believe the department is facing some difficulty in carrying out the amendment, but what is the difficulty is not being told to us. নিশ্চয়ই দেবে রিপোর্ট নিশ্চয়ই এসছে
Okay, where is the affidavit of asset? Paragraph 1, 2, and 5.
It's the affidavit of asset. I have a copy.
Department identified some defects in the para 1, 2, and 5 of the affidavit of assets. Para 1, 2, and 5.
No, it was. I have a copy of it, which the GA5 টা আছে সাহেবের কাছে মানে in GA5
as per the report.
Yes, I understand, man.
What is the defect?
We don't have GA5 page 28 is the affidavit of asset in GA5.
Page 28.
8 is affidavit of asset bearing the marking, the amendments we are.
Yes. Kindly come to your original affidavit of asset.
Yes, my lord.
Original affidavit of asset.
No. আমার কাছে copy নেই.
Where is your original affidavit of asset?
Well, the original is marked here accordingly.
So, in the original, first original,
my lord,
paragraph 1.
Yes.
Correct. Paragraph 1, okay, you have cut down. Defects in paragraph 1, 2, and 5. Yes, paragraph 1.
1.
Paragraph 1 starts original. It starts from that I being the son of joint executor, I am one of the joint executors.
My lord.
Correct.
Yes.
And you have given the affidavit of the amendment where you have mentioned and cut down.
না বুঝে গেছি আরে that portion is
first you have to write this paragraph and cut down, then this is to be read portion.
And I have done the new one only.
You are given the new one.
Altogether deleting the old one.
Deleting the old one, but that is not the proposal.
No, that cannot be. The old one will remain.
And that has to be strike out by the red pen.
Red pen, new one underline.
New one underline.
That's the only way.
You're not done. Then the same thing in paragraph 2 also.
No. Let's understand the mistake, then we'll correct it.
Same thing in paragraph 2 also.
Yes, it's the same thing because the original is not there, replaced by the new.
Replaced by the new and underline that. The same thing in paragraph 5 also. paragraph 5, not total. Paragraph 5 is that my identity. Paragraph 5 is okay.
Prove my identity.
Mine you cut down. Our is
Oh,
okay.
that
That
is
is
okay.
correct.
So it's only in 1 and 2.
1 and 2.
What the solution?
I am giving the leave to file a supplementary.
Supplementary
Amended, proposed amendment.
With proposed amendments.
That will be better.
Yes.
Otherwise,
because the problem is we are not being told what is the problem. From July last year, we are whatever. I'm not complaining anyone.
No.
It has
That's
to
why
be
they
solved.
came to me.
Yeah, okay.
They came to me. Then I find, yes, okay.
No,
let it come in the court.
We will do it.
So and so appearing for the petitioner. Full stop. Petitioner has filed an application being GA5 of 2024 for amendment in the affidavit of asset. Full stop. This court has allowed the amendment, and this court has allowed the said application. Full stop. At the time of carrying out the amendment, comma, department has found some defects in paragraph 1 and paragraph 2 of the proposed amended affidavit of assets, and accordingly the report has been placed before this court. Full stop. Considering the above, comma, the counsel for the petitioner prays for leave to file a supplementary affidavit of assets by correcting the proposed amendment. In view of the submission made by the counsel for the plaintiff petitioner, petitioner granted leave to file a supplementary proposed amendment of the affidavit of assets and application also.
No, it's only. I think the defect is only in the asset, the report.
Affidavit of asset in the yes.
Only in
within 2 weeks.
Well,
within 2 weeks from date. Let the matter appear on.
Now the department should carry out after I do it. After I.
Within 2 weeks. After filing the amended affidavit of assets, after filing the proposed amendment affidavit of assets by the petitioner, comma, the defendant shall carry out the same within a week thereafter.
The department will carry out. Week thereafter.
Week thereafter. 2 weeks file karo, then correction 1 week.
1 week.
My lord, they would serve upon the parties also.
Definitely.
After the amendment of the affidavit of assets in the probate application, the probate application or letters of administration?
Letters is now a LA is converted to a letters of administration.
Of the letters of administration, comma, the amended copy of the same of the application along with the affidavit of assets be supplied to the London Council for the defendant.
Great.
Obliged.
Hey, please, my lord. This is my application, my lord, for amendment of an affidavit of asset, my lord, that was affirmed on 16th of February 2023, my lord.
Affidavit of assets.
Affidavit of assets, my lord.
Amendment in the affidavit.
I am, my lord, the husband, my lord. The proposed amendment, my lord, is at page 54, my lord. Should be appearing, my lord, in red ink. My lord, this locker was inadvertently, my lord, not mentioned in the earlier affidavit.
You want to add this?
Yes, my lord. Because in the will, my lord,
Allahabad Bank presently merged with the Indian Bank. Account number so and so. Amount is not known.
Amount is not known.
Then that is only.
That is the only correction. Because, my lord, the will mentions the lockers, my lord. Upon subsequent searches, my lord, we discovered this locker existed, my lord, and therefore we plan to bring this on record. I am praying for prayers A2C of the master summons.
So and so appearing for the petitioner. The petitioner has filed the present application GA1 of 2025, praying for amendment in the affidavit of assets in paragraph 3, but as paragraph 3 within bracket III, by incorporating the locker of the by incorporating the details of the locker of the testatrix
my lord.
of the testatrix, which is available in the Allahabad Bank. Which branch? Park
Malad-
Street branch,
Malad,
Kolkata.
yes.
Consider the submission made by the counsel for the petitioner. This court find that the amendment as sought for by the petitioner is formal in nature and will not change the nature and character. Accordingly, prayer A to C of the master summon is allowed.
But I'm very sorry, my lord. I must only indicate it's para 2 triple I, my lord. My lord has my lord has
Triple I.
possibly given 3 triple I. I may have
2 triple.
I'm very grateful. I'm very grateful.
2 triple.
Very grateful.
2 I. ठीक है numerical 2 numerical 2 I small.
My lord, this is my application of probate. Last occasion, my lord, there was a direction to bring attesting witness.
Witness present?
Yes, ma'am.
Bring.
My lord, before it, may I submit something?
Yes.
My lord, the name of the attesting witness is appearing in the last will as Gopal Verma, and at the time,
file
and at the time of filing the affidavit of attesting witness, it is appearing as Sandeep Verma from his Aadhaar card. My lord. My lord, in respect of Gopal Verma, there is a affidavit which has been executed in the year 2013. I am submitting, my lord. In this affidavit, my lord, I, Gopal Verma, son of late Naresh Kumar Verma.
Correct.
Yes, my lord. And my lord kindly takes up his affidavit of attesting witness wherein his name is appearing as Sandeep Verma from his Aadhaar card.
Attesting witness, his name is working appearing as Gopal Verma.
Gopal Verma, alias
Not alias. That's why. Kindly
yes,
see page 4 of the
my lord.
Ah,
In the will, it is appearing as Gopal Verma.
Correct.
At the time of filing the affidavit of attesting witness, my lord, he has written as Gopal Verma alias Sandeep Verma because his name is appearing in the Aadhaar card as Sandeep Verma.
Gopal Verma. When you file the affidavit?
This affidavit, my lord,
23 June 2023.
yes, my lord. But what
And when this will was April 2007.
2007, my lord.
And you have given the affidavit
2013.
2013.
Yes, my lord.
And when the this card was issued?
This card was issued in the year 2018. Long time back, my lord.
21. 16 March 2021.
2021, it is revised, my lord.
Sandeep Verma.
It was amended. In 2021, it was amended.
Revised one.
Revised one,
Revised.
correct.
Yes.
2021.
It was revised, my lord.
What revised?
16th March 2021.
Correct.
Yes, my lord.
16th March.
He is the attesting witness, my lord.
Yes. Put the witness on box. Yes, record. आप मेरे पीछे बोलिए.
मैं
कसम खाता हूँ वो जो कुछ बयान दूंगा वह सच होगा मेरे बयान में कुछ भी झूठ नहीं होगा ईश्वर मेरी सहायता करे आपका नाम बताइए
गोपाल वर्मा एलियस संदीप वर्मा
गोपाल वर्मा एलियस
संदीप वर्मा
SANDEEP.
My lord, one more thing. But following from your lordship on that day, the photograph of Mr. Verma is appearing something else, and at the time of affirm this affidavit, it is something else, my lord. In the year 2020, he was detected as
okay.
liver
You
cirrhosis.
first that will be point of argument.
आपके पिताजी का नाम बोलिए.
Let the
लेट नरेश कुमार वर्मा.
Let the witness be completed first. That is the point of argument.
आपका उम्र?
अभी मेरा उम्र 41 है.
क्या करते हैं?
बिजनेस करता हूँ.
घर कहाँ है?
घर नेचुरलाइट्स में.
पूरा एड्रेस बताइए.
137 VIP रोड, नेचुरल हाइट्स, ब्लॉक 11, फ्लैट नंबर 1B. फ्लैट नंबर 1B. कोलकाता 52।
My lord, may I start? Mr. Verma, can you please tell my lord who has executed this last will dated 6th of April 2007? Can you please tell my lord the name of the deceased?
जो जो मारे गए हैं और जिन्होंने विल को
सुशील चंद्र भट्टाचार्य जी।
समझ में नहीं आएगा मुझे पूछ लीजिएगा, ठीक है?
Can you please tell my lord who is the other witness whose name is appearing in the last will dated 6 April 2007?
Witness is शांतनु भट्टाचार्य जी।
Whose name is appearing as other attesting witness in the last will dated 6 April 2007.
शांतनु भट्टाचार्य जी।
Can you please tell my lord as to why you have put your signature as Gopal Verma in the last will dated 6th of April 2007?
आपने अपना सिग्नेचर गोपाल वर्मा क्यों डाला था 6 अप्रैल का जो विल है उसमें?
मैंने गोपाल वर्मा का सिग्नेचर इसलिए डाला था क्योंकि मेरा नाम संदीप वर्मा ही है, लेकिन मेरे जो हमारे गुरुजी उन्होंने कहा था कि गोपाल वर्मा के नाम से आप काम करेंगे तो आपको अच्छी सक्सेस मिलेगी।
I had put the signature as Gopal Verma, but my name is Sandeep Verma. My Guruji had asked me to put my name as Gopal Verma, as it will be good for me and
for the luck of business.
For the luck of business.
Mr. Witness, can you please tell my lord under whose instruction you have put your signature in the last will dated 6 April 2007?
आपने किसके कहने पर उस विल में अपना सिग्नेचर डाला था?
ये मिस्टर सुशील चंद्र भट्टाचार्य जी मेरे फादर के अच्छे फ्रेंड थे, तो मेरे फादर से उनकी अच्छी दोस्ती यारी थी, तो फादर वो हमारे यहाँ उनका रेगुलर आना जाना था, तो उन्होंने जब मुझे बोला तो फादर ने कहा जाके विल में साइन कर दो।
Mr. Sushil Chandra Bhattacharya was a good friend of my father, and he used to visit our house very often. So when he asked my father that I may put my signature, my father had told me to put my signature on the will.
Now, Mr. Witness, I am showing you a document. Page number 11, Annexure A.
Yes, yes.
Can you please tell my lord whose name is appearing in the first line of the last will?
सुशील चंद्र भट्टाचार्य जी।
Circle it in blue.
Yeah.
Not like this. Can you identify the signature?
Yes, sir. Yes, sir. जी सर।
Now I am showing you.
How you can identify the signature?
सर ये वाली साइन है सर।
How? आप कैसे उसका सिग्नेचर को आइडेंटिफाई कर रहे हैं?
सर क्योंकि मेरे सामने साइन हुई थी उनकी।
I can identify the signature because it was put in my presence.
और कौन था आप जब साइन किए तो?
सर मैं अकेला था सर, उस समय मैं था और उनके लड़के थे शांतनु भट्टाचार्य जी।
I was alone and his son
शांतनु भट्टाचार्य जी
was present there.
Can you please encircle the signature of Mr. Shantanu Bhattacharya ji?
Yeah.
Let first testator.
The witness encircles the signature of Sushil Chandra Bhattacharya in blue. in all pages.
ऑल पेजेस।
जहाँ
कितना
जहाँ
सिग्नेचर है?
हाँ सर,
कितना सिग्नेचर है?
सर 4 सिग्नेचर है उनके।
क्या बनता
the Sushil Chandra Bhattacharya
है? तो हम बुलाया
in the will. Oh,
और किसका सिग्नेचर है?
और
सर उनके लड़के की साइन है।
आपका है?
हाँ सर, मेरा भी है।
अच्छा लीजिए
आप अपना सिग्नेचर इंसर्ट कर कीजिए राइटिंग में।
आपका अपना वाला रेड में कीजिए।
जी
Mr. Witness, can you
जस्ट हाउ और कौन सा था? और कोई साइन किया था उसमें?
सर, उनके लड़के ने साइन किया था।
आप उसका साइन आइडेंटिफाई कर सकते हैं?
जी सर। रेड में
इन रेड रेड में कीजिए।
खाली साइन में कर दिया।
इन रेड
थ्रू कोर्ट। हाँ,
टू कोड।
जो आपने साइन सब किया, आप पहचाने हैं, क्या डॉक्यूमेंट है ये?
क्या?
क्या डॉक्यूमेंट में आप लोगों ने साइन किया था?
सर विल के कागज में।
किसका विल?
ये सुशील चंद्र भट्टाचार्य।
The document on which we have signed, that is the document, that is the will executed by Sushil Chandra. Yes, next question. No, just a minute. The will is marked as Exhibit A, comma, signature of the testator is marked as Exhibit A by 1 to
A by 4.
A by 4. Signature of this witness is marked as Exhibit A by 5. And signature of the another attesting witness, namely
Santanu
Bhattacharya.
Santanu Bhattacharya, marked as Exhibit A by
A by
6.
6.
Yes, next.
Mr. Witness, can you please tell my lord what is the date of the last will?
इस will को कब सिग्नेचर किया गया?
6 अप्रैल 2007।
Is it appearing in the last will? Can you please see and can you please check?
यहाँ will में देख के आप बताइए कहाँ वो date mention किया है।
Page.
पेज नंबर 4।
Can you please encircle the
No, not necessary. आपने बोला थ्रू कोर्ट। हाँ, आपने बोला ना कि आपके सामने आपने गए थे, साइन किया है। उनका फिजिकल कंडीशन क्या था?
सर उस समय तो उनका मोटा नॉर्मल था उनका हेल्थ।
You said that you signed, you had, you had signed.
What was the condition of the testator at the time? What was the physical and mental condition of the testator at the time of execution of the will? Answer: it was normal.
Yes sir.
Yes, anything?
No, my lord, I am forward.
Wedding photo.
ठीक है, उतर जाइए।
थैंक यू सर।
Consensus offering for the petitioner. Petitioner witness is present. One of the attesting witness and petitioner witness is present, who is the one of the attesting witness of the last will and testament dated. What is the date of the will?
My lord,
6 April 2007.
April 2007.
April 2007. Full stop. During his evidence, the will is marked as Exhibit A, comma, signature of the testator are marked as Exhibit A to A1 to A4, comma, signature of this attesting witness is marked as Exhibit A5, and the signature of the other attesting witness is marked as Exhibit A6. Full stop. Evidence of the plaintiff witness is closed. Witness is discharged. Counsel for the petition submit that she will not adduce any evidence. Adduce any further evidence. Full stop. Let the matter appear on 24th January for argument.
My lord, affidavit is submitted. Kindly be recorded.
You have not taken that. Not necessary.
My lord.
You take back.
My lord.
Otherwise, it has to come on evidence.
My lord.
Yes, next.
Yes.
I'm appearing on behalf of the petition.
Yes.
Lordship, this is the application for grant of letters of administration with the will annexed.
With the will?
With the will.
Where is the will? All formalities completed?
Yes, my lord.
Where is the will?
Will is at page 10, page 11. It's a Bengali will.
Who is the executor? Apurva. Apurva. Who is the executor?
Executor is
Apurva.
Abhijit Maulik, represented by his constituted attorney.
Executor is
Abhijit Maulik.
Where it is mentioned?
In the cost title.
In the will, name is mentioned?
Yes.
Where it is? Sriman Abhijit Malik, son of my own younger brother, Sriman Arvind Malik, or in the event his unfortunate death during my lifetime, his heirs. This is the only?
Yes.
And who is the petitioner? Same? Abhijit Malik is there?
Abhijit Malik is one of the beneficiaries.
He is the petitioner?
He is
the petitioner here?
Petitioner. Represented by his constituted attorney, Sudeep Kumar Datta.
Why constituted attorney?
The relevant point of time, the executor is residing in Canada for his occupational purpose. That's why he has executed a special power of attorney and thereby empowering Mr. Sudeep Kumar Datta.
When the testator died?
Testator died on 11th of February 2020.
Where is the death certificate?
Death certificate is at page 10, Annexure A.
Died on?
11th of February 2020.
Page 10.
Page 10.
11/10/2020. And what is the date of the will?
Date of the will is 22nd of September 2011.
22nd September 2011. Yes. So what about the legal heirs?
Legal heirs is her only daughter.
Where is that?
It has been
Alka Ganguly.
Aloka Ganguly.
She has given the consent.
Subsequent to citation.
She has given citation and consent.
Yes. May I file the consent?
Not filed in the court.
Earlier, it has not been listed before the court. I tried to file it.
It could have been filed in the department.
I tried, my lord. The department told that the matter, when it will be called on, will file in the court.
Citations were issued.
Yes, my lord.
Attesting witness.
Attesting witness has filed his affidavit and also the declaration at the at page 9 of the application of the petition.
What about the wife?
Wife have died after the date of the deceased.
What is the date of the death of the deceased wife?
12th of July 2021. And
July
the death certificate has been annexed.
So appearing for the petitioner. The petitioner has filed the present application for grant of letters of administration of the last will and testament of the testator Apurva Kumar Maulik, M-A-U-L-I-K, huh? Maulik, dated 22nd September 2011. The counsel for the petitioner submitted the testator died, leaving behind his wife and one daughter. But after the death of the testator, the wife has also expired. Only one legal heir is surviving. Only one surviving legal heir, that is a daughter, is available. Is present.
Only
On after the death.
after the death of the testator, only one.
No, which card? After this, wife also died on so and so. Okay. Police counsel for the petitioner submit that the petitioner is the beneficiary of the last will and testament. Full stop. The counsel for the petitioner submit that though the daughter has not given affidavit consent before filing of the present application for grant of letters of administration, but subsequent to filing of the application and issuance of citation, the daughter has given her consent, stating that she has no objection for grant of letters of administration to the petitioner with respect of the last will and testament dated 22nd September 2011. The counsel for the petitioner submit that citations were also issued, but no one has come forward to raise any objection for grant of letters of administration to the petitioner. The department has also submitted no caveat certificate dated 19th November 2024, wherein it is mentioned that no caveat has been entered against the grant of letters of administration. The petitioner further submit that one of the attesting witness of the will has also filed his affidavit stating that the testator has executed his last will and testament in his presence and in presence of the another attesting witness while possessing good health and fit state of mind. Police heard the learned counsel for the petitioner, perused the original will, death certificate of the testator, death certificate of wife of the testator, affidavit of consent of the daughter, affidavit of the attesting witness, and no caveat certificate submitted by the department. This court finds that the petitioner has proved the will and is entitled to get the letters of administration of last will and testament dated 22nd September 2011. The last page card. Considering the above, this court finds that the petition is entitled to get the letters of administration of the last will and testament dated 22nd of November 2011. The office is directed to issue letters of administration to the petitioner subject to furnishing surety of what is the total amount of assets? 50 lakhs
approximately.
Of rupees 5 lakhs, surety of rupees 5 lakhs with surety of furnishing surety of rupees 5 lakh with two sureties within bracket 2,50,000 each on compliance of all formalities at the time of grant of letters of administration, the copy of the will be made as part of the administration. PLA number so and so disposed of.
Well, apart from the petitioner, there are other beneficiaries also.
One of the beneficiary.
The daughter is one of the beneficiary, the petitioner is one of the beneficiary, and the sister of the petitioner is the beneficiary.
He is the one of the beneficiary. Yes. He has come forward.
Yes.
Lord, I am appearing on behalf of the petitioner, my lord. This is my application under section 283(3) of the Indian Succession Act. It's a very innocuous application, my lord. I'm seeking prayers for the issuance of citations through two district courts within the jurisdiction of which a few immovable properties are situated, my lord.
Which area?
My lord, I have indicated
District Judge Karkadoma,
Kakaduma Court, my lord, in Delhi, and the other would be the District Judge Churu.
Rajasthan.
Yes, my lord. My lord, I have indicated the details of the properties in paragraph 2.
So and so appearing for the petitioner. The petitioner has filed the present application for issuance of citation under section 283 within bracket 3 of the Succession Act as three of the properties, four properties.
Yes, my lord, I have indicated that in paragraph 2, my lord.
As altogether 1, 2, 3, 4, 5, 6 properties are situated outside the state of West Bengal and is situated in the
My lord, not 6, my lord, 5 properties.
1, 2, 3.
Yes, my lord,
4,
A,
5,
B,
6.
C, D,
E, F.
and E.
So why F you mentioned?
My lord, I have mentioned because I have indicated all those properties in the PLA, my lord. So that's why, for the sake of convenience, I have mentioned all the properties.
5, huh? 5 properties situated. Then counsel for the petitioner submit that out of 5 properties, Delhi, only one is in Delhi.
No, my lord. There are total 6 properties.
One is in Delhi.
Yes, my lord. 1 is in Delhi and 4 are in Churu.
Out of 6 properties, 1 is in Delhi, 4 are in Churu district, Rajasthan, and another is in state of West Bengal. Considering the submission made by the counsel for the petitioner, prayer A, B, and C is allowed. J1 is dispensed.
I'm extremely grateful, my lord.
My lord, I am appearing on behalf of the petitioner. The only property situated at Salt Lake, the testatrix died at Chandigarh. Her husband is still alive and 3 daughters. We have sent citation by special citation and general citation. They had not given consent. That is why citation prayer was applied for. I have always I have filed also an additional affidavit of one affidavit of service wherein the newspaper publication at Chandigarh, both in Hindi, Gurumukhi and English, I have annexed. And there is also a report of the sheriff office that special citation have been served on the 3 people.
Who is the testator? Testatrix? Testatrix.
Yes.
So here's where is the name of what is the date of the will?
The date of the will 2001.
2002, 2001. Where is the name of the executor?
Executrix is Srimati Rama Devi Mundra.
Where is that?
In the will, your lordship will find in paragraph.
Which page?
Page 11, paragraph 2.
I hereby appoint Ramadevi Mundra.
Yes.
As executrix of his last will. Yes. When he died. Where is the death certificate?
Death certificate, your lordship will find at page number 16, Annex B. Date of the date is 17 July 2022.
17th July
2022.
You have stitched as like how the court can read this. 17 July 2022.
Yes.
22 years. Then
an application has been made on.
Where is the legal years?
Legal years I have stated in paragraph 6A to 6D at page 3
so
and 4.
Singh is the husband.
Husband is still alive.
And they are the daughters. Nobody has come forward.
Nobody has come forward.
So and so appearing for the petitioner.
Any
petitioner has filed the present application for grant of probate of the last will and testament of the last will and testament dated
the lordship will find
10th June 2001 of the testatrix Srimati हरचरणजीत कौर, HAR, ठीक है, हरचरणजीत कौर, full stop. Counsel for the petitioner submit that the testatrix has executed her last will and testament by appointing the petitioner as sole executrix of her last will and testament in presence of two attesting witnesses. Full stop. Counsel for the petitioner submit that the testatrix died on 17th
Lord, 17 July
2002,
2000,
leaving behind
2022.
2022, leaving behind 2022, leaving behind her husband
and three daughters. All are staying at Chandigarh.
Full stop. As none has come forward either to give consent or to file caveat or affidavit in support of caveat, accordingly citations were issued and publication were also made at Chandigarh for the information of the legal heirs of the testatrix, but in spite of the issuance of citation and publication of the notice, none has come forward to raise any objection for grant of probate or to give consent. The department has submitted no caveat certificate stating that no caveat has been lodged, raising any objection for grant of probate. The one of the attesting witness, what is the name of the attesting witness?
My Lord, Dilip. Just a moment.
Where is that?
At page 13, at the bottom of the page 13 of the will.
Dilip Kumar Mudra.
Mundra.
One of the attesting witness of the will, namely Dilip Kumar Mudra, has filed his affidavit stating that the testatrix has executed her last will and testament in his presence on 10th of June 2001 while possessing good health and fit state of mind by appointing the petitioner as the testatrix of as executrix of his last will, of her last will. Full stop. Had the learned counsel for the petitioner produced the original will, comma, affidavit of the attesting witness, comma, death certificate of the testatrix, and the no caveat certificate issued by the department. This court finds that in spite of issuance of citations and publication of the notice, none has come forward to raise any objection for grant of grant of probate. Full stop. The department has also submitted the certificate that no caveat has been lodged. One of the attesting witness of the will in his affidavit has categorically stated that the testatrix has executed her last will and testament while possessing good health and fit state of mind by appointing the petitioner as her sole executrix of her last will. Considering the above, this court finds that the petitioner has proved the will and is entitled to get probate of the last will and testament.
Priority of the petition will.
Full stop. Considering the above, full stop. The department is directed to issue probate to the petitioner. Issue probate to the petitioner.
At page 6, priority. Prayer.
To the petitioner on compliance of all formalities. At the time of grant of probate, the copy of the will be made part of the probate. PLA is disposed of. Next.
I appear for the applicant, my lord. This matter, my lord, initially probate application was filed, my lord. Thereafter, it has been converted into letters of administration, my lord, by an order dated, my lord, 23rd of August 2024. My lord, the difficulty is that, my lord, the applicant is suffering from throat cancer, my lord, so he's bedridden, so he cannot come. My lord, the applicant is suffering from throat cancer, my lord.
Yes.
So he cannot come down to the court to, my lord, to reaffirm the application, my lord, because for my lord, it has been converted from letters from probate application to letters of administration.
Why?
Because initially when the probate application was filed,
why it was converted?
Inadvertently the probate application was filed because there was no named executor. Thereafter, it has been converted into letters of administration.
So now what you want?
Lordship's leave to, my lord, affirm and re-verify the applications, amended applications through notary public, my lord, if that can be done, my lord.
Where is the document that your client
I have some medical documents, my lord, of November, my lord. May I just hand over, my lord? It's not originals, my lord, but Xerox copies, my lord.
You file the affidavit, a short affidavit disclosing all the document. File an application
This would
disclosing.
prolong the matter, my lord. This would prolong the matter, my lord. If my
How
lord
the
wants
court
just-
can enter that? This a will. Come with an original document with an affidavit. I will see to that. How?
Very well, my lord.
As
Then
per the prayer made by the counsel for the petition, the case adjourned. Let the matter appear on 12th of February.
my lord, an application in affidavit form.
Come.
Very well. May I just take back the, my lord, document?
ये दे दो उनका document. Document का है. Next.
Grateful to your lordship.
I am for the petitioner. Petitioner is the legal heirs of the testatrix. Other legal heirs refuse to file the petition, consent petition. Other
Yes.
legal heirs. I am the legal heirs of the testatrix.
You are one of the legal heirs of the testatrix. Yes. So what has happened?
Citation may be issued to other legal heirs.
How many
As well,
legal heirs are there?
there are 3 legal heirs, including petitioner.
3 legal heirs. What is the name of the petitioner here?
Petitioner
Ashok Goyal. Ashok Goyal, the petitioner. Yes.
Pramod Goyal.
Other 2 sons.
Sons.
What about the husband?
Executor, husband died.
Husband also died. So no caveat has come. No consent has
special
not
cite-
come.
Special citation and general citation and paper. One of the property is situated at Delhi.
Where is the 283 application?
Where I am not filed.
How that can be? So appearing for the petition. Counsel for the petition submit that the testatrix died leaving behind 3 legal heirs, including the petitioner. But none of the legal heirs have come forward either to give consent.
Executor refused to file the petition. Executors refused to file the petition. I filed the PLA case. LA, sorry.
Whether this petitioner he is not the executor?
No.
So what petition you filed?
Petitioner
What
is
is your
the
prayer?
legal heirs of the executives. One of the legal heirs.
One of the legal heirs, he is not the executor of the will.
No.
So how the
Executors is his brother Binod Bansal, who refused to
who?
file the Binod Bansal.
Vinod Bansal is not the legal heir.
No.
So he has not come forward. So you file this application for grant of probate of the will.
LA.
Madam, LA, this is High Court. What is the LA? Land acquisition.
Letter of administration.
So? क्या बोला? No, petition पूरा कर दो. The petitioner पूरा कर दो. The petitioner has filed the present application for grant of letters of administration. For counsel for the petition submitted that though the testatrix. So how you can file the affidavit unless and until they have been renounced?
Well, I am opposing in that case, my lord. I am representing one of the son, my lord, and my lord will remember in one of the matters suit the MOU that has been where I don't know what is there, my lord. That particular MOU has been stayed, my lord. Mr. Anirban Roy appeared, my lord. It has been subsequently extended, my lord. I also appeared in that matter. So
that's correct. That is.
I don't know what is there, my lord.
This is the will. In the will, there is an executor. Correct. Executor has not come forward. So what do you want? Unless you first you have to renounce this, executor has to renounce. Then only you can come. Take instruction from senior. What is to be done? As per the prayer made by the counsel by the petitioner, the case is adjourned. Let the matter appear on 18th of February. Yes, anything?
33 minor.
Huh?
33 minor.
What is there?
Grant of probate minor on consent.
My lord, the 33 grant of probate, my lord, for will dated 25th July 2013. The testator died on 3rd May 2021. Paragraph 3 are the names of the legal heirs, my lord. The wife and 2 daughters.
Wife
And 2
widow,
daughters.
2
All have given consent. All have given consent.
Who is the executor?
The executor is the wife. Your lordship will find that from the will, annexure A, paragraph 2. Madhu Jajodia.
Madhu Jajodia is
She has applied. She's the wife and applied for.
She's the executrix.
Executrix applied for the
Grant.
grant.
And, 2 legal heirs.
2 legal heirs.
One is the daughter and both are daughters.
Both are daughters. Both have given consent.
Where is the consent?
My lord, it's annexed, but not numbered because it's original.
Brinda Sarangi.
Brinda Sarogi and
Seria
and Bharti Upadhyay.
Yeah, Bharti Upadhyay.
2 consents, my lord. The death certificate is as annexure B.
Just a minute. Just a minute. Where is? Yes, Bharti Upadhyay. Yes.
The death
And
certificate is
attesting
annexure
witness?
B.
Attesting
Attesting witness Shreya Basu Malik. Affidavit is there, my lord, in the records.
Shreya Basu Malik.
Your lordship comes to the will. The signature of Shreya Basu Malik also appears in the will as an attesting witness.
Date of death?
Date of death is, my lord, 3rd May 2021. Death certificate is annexed as annexure B.
So appearing for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated 25th of July 2013, executed by the testator Dilip Kumar Jajodia. The counsel for the petition submitted. The testator has executed his last will and testament by appointing the petitioner as sole executrix of his last will and testament while possessing good health and fit state of mind in presence of 2 attesting witnesses. Full stop. Counsel for the petition submitted. The testator died on 3rd of May 2021, leaving behind the petitioner being the wife and 2 daughters. He submitted both the daughters have filed their affidavit of consent, stating that they have no objection for grant of probate. One of the attesting witness, namely Shreya Shreya Basu Malik, has also filed her affidavit, stating that the testator has executed his last will and testament in her presence and in presence of other attesting witness by possessing good health and fit state of mind by appointing the petitioner as sole executrix. Had the learned counsel for the petitioner peruse the original will, death certificate, affidavit of consent of all the legal heirs, and affidavit of the attesting witness. This court findeth that the legal heirs have categorically stated that they have no objection for grant of probate to the petitioner. The attesting witness in his affidavit stated that the testator has executed his last will and testament while possessing good health and fit state of mind, while possessing good health and state of mind by appointing the petitioner as sole executrix. Considering the above, this court finds that the petitioner has proved the will and is entitled to get the probate. The department is directed to issue probate to the petitioner of the last will and testament dated 25th of July 2013 upon completion of all formalities. At the time of grant of probate, the copy of the will be made part of the probate. PL is disposed of.
My lord, one mentioning before your eyes.
At time? At this time?
Shall I come back at 2 p.m.?
What is the mentioning?
My lord, item number 2 of the commercial list came from the warning list. So it's a matter regarding the IPR. My lord doesn't have the determination. My lord has put it in, has done it dismissed for default.
Okay, comment 2 I will see. देख लेना. So let the report come. Now let the decree department submit the report. What is the problem they are facing? We will see to that.
My lord, then finally keeps it on any day, my lord.
Let the come, then we'll see to that. If the file will come, then it will be listed.
My lord, can I communicate?
Let them send the report. उनका क्या है? So why you are not appearing? When the suit is mentioned, earlier mentioned not appeared. Went to the warning list, you are not appeared.
Our counsel was not present.
Who are you? You are not the counsel. A record. Item number 2. Huh? Who has taken the dictation? Morning. So appearing for the plaintiff. It is fine from the record. The suit filed by the plaintiff is connected with the intellectual property matter and filed in the year 2023. Thus, this court is not having the determination accordingly. CS Com 9 of 2023 is deleted from the list of this court. It is fine from the record. The department has not assigned the IP number. According to the department is directed to assign the IP number and to place before the appropriate bench having determination. Yes, call the matter.
My lord, these are 3 undefended suits. Where, my lord, the witness is now there to depose. I'm for the plaintiff, my lord. Would your lordship kindly allow me? Yes, my lord. Witness is present. Yeah, my lord.
Praise the witness.
Yes. Witness is Anil Agarwal. Anil Agarwal. Who is Anil Agarwal? Judges brief दे कल को 1 2 3 करके निकाल लो.
I solemnly affirm that in whatever I will depose by way of evidence in this suit I shall speak the truth and no part of it shall be false and I shall not conceal anything. What is your name, sir?
Anil Agarwal.
Anil Agarwal, son of
Om Prakash Agarwal.
Om Prakash Agarwal. Age
52.
Occupation
Business. আপনি তো বললেন আসতে বলতে মানে
address
21/3 SN Chatterjee Road
21/3
SN Chatterjee Road Calcutta 38 52.
These are all obtained. And copy, original copy of the complaint made to the police. In this complaint, 31st December 2023.
আমার গলাটা বসে আছে না এই জন্য মানে বুঝতে পারছি না কিভাবে হবে
Yes, continue.
Yes. Miller, the affidavit of evidence. Mr. Agarwal, what is this document?
This affidavit.
Have a look at it.
take your time and answer.
This is my affidavit for evidence.
Affidavit of evidence.
Who has prepared this affidavit?
My advocate on my instruction.
My advocate on my instruction. Who has signed this affidavit?
I have signed this.
On which page does your signature appear?
In the 16th page.
What do you have to say about the contents of this affidavit?
They are true and correct.
What do you have to say about the contents of this affidavit?
It's true and correct.
What is the date?
On which date have you affirmed this affidavit?
I have affirmed it today. Today. 17th of January 2025.
Today, 17th January 2025.
Yes, next.
Shown pages 1 to 47 of the judge's brief of documents. Volume 1. What is this document?
This is judge's brief of document.
No.
Page number
I'm
1 to
showing you
47.
pages 1 to 47 of the judge's brief of documents. Kindly see pages 1 to 47
Yeah.
and tell the court what is.
It's the copies of the bank statement.
Sorry?
It's the copies of the bank statement downloaded from the official website of United Bank of India.
Slowly.
Of United Bank of
India, now PNB.
What does this bank statement show?
The bank statement shows the payment made by me to UK traders.
To
UK
traders.
U.K traders.
UK traders.
Yes.
What is UK traders?
It's the concern in which we have made the payment. I have made the payment. I have made the payments.
I had made the payments.
Who's the proprietor of UK
Uttam
traders?
Chatterjee.
Of UK traders, Mr. Uttam Chatterjee.
ফার্স্ট আনসারটা কি ছিল? কোথা থেকে ডাউনলোড করলো বললো? অফিসিয়াল ওয়েবসাইট বলে দিয়েছে তো? হ্যাঁ। What do you have to say about the contents of this document?
It's true and correct.
Incorrect. My lord, let this be marked as an exhibit. Since it's been downloaded, my lord, from the website, there are a few more documents, and there is a common 65B which I will place before your lordship. Let this be marked as an exhibit, my lord.
Have you affirmed the affidavit?
Yes, my lord. It's
65B?
there. Yes, I'll tender it before your lordship. I'll run it past the witness. My lord, once all
Okay.
questions are done, I'll then run it past the witness.
How many pages? 1 to
47.
Exhibit A.
No, it's okay. Collect. Yeah, bank collect. All collect. Shown pages 48 to 1252 of the judge's brief of documents. Take your time. Please see all these pages. 1252.
Commencing from volume number 1 to 8. Volume number 1 to 8.
1253 किसमें कर देते हैं भाई?
1253.
पक्का शब्द दिए दिन. Take your time.
1253 आधा 8 में आधा 9.
Thanks, bro.
So, one by one.
It's on the.
ठीक है
Mhm.
इसको भी just go through it.
Yeah, it's not.
Exhibit mark by হ্যাঁ ঠিক আছে বন্ধুর সঙ্গে
Show me one look. एक दो एक और नहीं जो देख लिया ना
মাটা দেবো does my lord need an extra copy my lord I have my brief
these are the different dates.
Yes.
So how it will go together?
my lord these are the should I my lord answer in the witness's presence
Okay.
Depending upon the answer perhaps my lord your lordship would take a call whether it is to go in
One 1252
1252 হ্যাঁ
last yes
হ্যাঁ ওইটাও দিয়ে দিন चालू कहाँ का डीट चालू हो रहा है
The last.
40 gets first year है 48 उसके बाद सेकंड डेट ये देखिए अगर कोई अलग है कि है ना आगे थर्ड बीच से खाना होगा नहीं उस वजह से पूरी बात करना होगा जैसे वो डिस्क्रिप्शन है नहीं तब तक रेडी हो जाते हैं
yes next
yes what are these
These are the copies.
what
of
are these documents let the question complete please what documents are reflected between pages do the number 48 to 1252 of the judge's brief of documents
No answer.
These are the copies of the agreement for sale entered by Uttam Chatterjee with the seller using my money.
My money.
the answer with these sellers using my with the sellers seller আছে না sellers আছে
Sellers.
using my
money
using my money how have you obtained these agreements for sale
I have downloaded it from the official
please
website.
answer slowly to the to the court
I have downloaded those. Yeah, I have downloaded those from the official websites of Government of West Bengal, Directorate of Registration Revenue. Yeah.
Directorate of Registration and Revenue.
What do you have to say about the contents of these documents?
These are true and correct.
My lord, let these agreements, there are a bunch of agreements which have a common person in whose favor a right is being created. So let these agreements, my lord, collectively.
How?
My lord, because may I, my lord, just ask the witness to step out for a moment and then give an answer. Please, if you can just step out.
ভলিউম 8 থেকে পাবেন।
No, no, 1 second, 1 second. Since it's marked for identification, I will come back to this document because I may have to ask a few more questions on this. Very well. Shown 1253. হ্যাঁ দেখানো এটা 125 125 what is this document?
This is the GD copy of check lost from my office.
Before whom has this GD been lodged?
With the officer in charge, Behla police station.
Who has signed this document?
I have signed it.
What do you have to say about the contents of this document?
This is true and correct.
Originals here, but this may be marked as an exhibit. If I have to ask you so many questions, what is the point of putting all this on affidavit? Contents of which? True and correct.
B. No, show. This is original. Shown.
Yes, my lord, this is the original.
Shown the witness.
Yes. Yes, sir.
This is the original.
Yes, sir.
Exhibit B.
Exhibit B. Shown pages 1254 to 1268 of the judge's brief of documents. निकाल एक बार. नहीं ये नहीं है 1254.
वॉल्यूम 9 है।
हाँ हाँ. Original. Yeah. হ্যাঁ 1254 and the other pages কি কত অবধি বলেছি হ্যাঁ
Yes, what is the question?
Yes, what kindly see the document at page 1254.
Yes, sir.
And other documents until page 1268. What is this document?
So the first one is the notice
Please
given.
identify the page number.
Yes, sir.
First one at page
1254 to 1263.
1268.
1263.
1263.
3 sorry.
Yes,
63.
Yes. What are the documents?
These are the notice given from my side to Uttam Chatterjee for repayment of the money that I have given to him. And the rest is the AD slip and their track reports. Track reports.
क्या बोला? AD slip. Acknowledgement. Acknowledgement.
Sir, speed post slip.
Speed post receipt.
Sorry, sir. Speed post receipt. Sorry, sir.
Postal receipt.
Yeah, postal receipt.
Speed post receipt.
Post
And track reports.
track reports. 1262. And
Who has signed? Who has signed this document?
sir, my office staff have signed on my instruction.
What is the name of the office staff?
She was Sir Priya.
Hmm?
Priya Roy. Priya Roy.
Priya Roy. Office staff Priya Roy. How do you how do you recognize her signature?
Because she gives this signature regularly. It's a regular signature.
She gives us.
Yes, next.
What do you have to say about the contents of this document?
It's true and correct, sir.
True and correct. My lord, original of the.
Sure.
Yes. Yeah, sir. This is the originals.
These are the original documents.
Let this be, my lord, marked as an exhibit.
Exhibit C collectively. Next.
Pages 1269 and 1270. 1269 and 1270. Shown pages 1269 and 1270 of the judge's brief of documents.
Sir, you have said from page 1254 to 1268.
Sorry. Yes. No, correct.
No.
One moment. Yes. I skipped a document in between. From 1264.
Yes.
Sorry. Shown pages 1264 to 1268 of the judge's brief of documents.
Yeah.
What is this document?
This is the reply from advocate of Uttam Kumar Chatterjee to us.
This is a reply of Uttam Kumar Chatterjee to us.
From the advocate of
Uttam Chatterjee, sir.
This is the reply of the advocate of the Uttam Kumar Chatterjee to us.
How was this received by you?
Sir, in the general.
That I have given to the analyst are the postal right.
ठीक है. वो करता क्यों पड़ा ओके Mr. Lakhani.
Yes, my lord.
Initially, you put the question 1254 to 1268.
No, 63, my lord. I corrected myself. 3 and 8, my lord, sometimes
Okay,
in
three.
poor
Okay,
handwriting,
okay.
my lord, appear
Next,
to be
next.
similar.
Continue further.
63.
Yes, 63, then no problem. Yes.
64 to 68. Key reply answer chilo, madam. How was this reply? How was this reply received by you?
During the due course of business, sir.
During the due course of. Let this reply, my lord, be marked as an exhibit. I'll tend to the original.
Show the original.
Yes. Original. Please identify the original.
Yes. Yes. Yeah. So this is the original, sir.
Marked as exhibit D. Yes, next.
Shown pages 1269 to 1270. What is this document?
So these are the ledgers of our company's payment made to UK traders.
Who has prepared this ledger?
So this is prepared by me in my office and with my computer.
This is prepared by me. Very well. Very well. Have you matched the entries in this ledger
Yes.
with that of your bank statement?
Yes, sir.
What did you find upon matching the entries of this ledger with your bank statement?
It was true, right, sir. The entries that has been in the bank statement is reflecting as true and correct, sir.
What do you have to say about the contents of this
So it's true
ledger?
and correct, sir.
Correct. Let this ledger, my lord, be marked as an
Exhibit E.
Exhibit done. This is ledger. Originally, yes, originally. Exhibit E. And
The office copy of the ledger.
ठीक है, done.
Yes, next.
Yes. Last, my lord.
No, second.
Shown pages 1271.
क्या हुआ? No, original office copy.
Office copy.
Original office copy.
Yes, next.
1271 to 1321. मार्क हो गया बस इसको एक से मार्क करना है 1271 to 1321 of the judge's brief of documents. What are these documents?
These are the, sir, cancellation deed of agreement which he have cancelled. Uttam Chatterjee have cancelled after buying. After doing the agreement for sale which he have done previously. Okay.
आस्ते आस्ते बोलिए ताकि वो लिख पाए.
Cancellation agreement.
Cancellation agreement or deed?
So cancellation of agreement.
Cancellation of agreement.
For sale.
For sale. Dated?
It's 9th August 20.
Milord, there are a bunch
16,
of
sorry.
bunch of documents.
16th, no sir, 16th day of August 2021. Yeah.
How many agreements are there?
Sir, two agreements, sir.
Another dated?
It's the same, sir.
Yes.
Where have you obtained these?
These were also, sir.
Let me please at least complete my question. What if I ask you the color of your shirt?
No, sorry.
Yes.
I'm sorry, my lord. কি জিজ্ঞেস করছিলাম? Where have you obtained these agreements of cancellation from? কি আনসারে কি বলেছিলেন? Agreements of cancellation. No. How did he ask it in his? Where did you obtain these cancellation of
agreements
agreements of sale from? Agreements for sale from?
Sir, I have downloaded it from the official website of Director of Registration Revenue, Government of West Bengal website.
ठीक है doesn't matter ठीक है doesn't matter ठीक है doesn't matter.
Yes, next.
What do you say about the contents of these documents?
These are true and correct.
This may be marked.
That's all. No.
No, of course, as your lordship marked earlier ones for identification, and my lord.
X1 for identification.
Yes. May I run the
X1 for identification collectively.
May I run the 65B past my witness, my lord? Shown at the affidavit of evidence. What is this document?
So this is my affidavit for electronic evidences.
Who has prepared this affidavit?
So my advocate on my instruction.
My advocate on my instruction. Who has signed this affidavit?
Sir, I have signed it.
On which page of the affidavit does your signature appear?
Page number 3.
What do you have to say about the contents of this affidavit?
It's true and correct.
Let this exhibit affidavit of evidence. My lord, this is a very tense. Those two identified documents, my lord, I will take steps for having them exhibited in the.
This is one case.
This is, my lord, one case. Similar, there are two similar, my lord, suits.
Not present.
No, same, my lord, same witness, similar questions, same facts. More or less, pretty much on similar lines.
Continue today.
I can, my lord.
Continue.
I can. Matters simple. Records are very, very voluminous. Now, 78 আছে কোথায় 78 কোথায় কল করে দিন আইটেম কল করে দিন আইটেম হ্যাঁ আবার ওথ হবে get down and come back again.
No, it's continued.
Okay.
Same evidence.
I solemnly affirm
only the
that,
case number will be changed.
solemnly affirm that
in whatever
I will depose by way of evidence in this suit I shall speak the truth and no part of it shall be false and I shall not conceal anything.
Anil Agarwal, sir. Om Prakash Agarwal, age 52, occupation business, and residence address is 21/3 SN Chatterjee Road, Calcutta 38.
To an affidavit. Show an affidavit of evidence. What is this document?
So this is the affidavit of for my evidence. For my evidence.
Who has prepared this affidavit?
My advocate has prepared this on my instructions.
Who has signed this affidavit?
I have signed.
On which page of the affidavit does your signature appear?
Page number 13.
On which date?
13.
On which date has this affidavit been affirmed by you?
17 January 2025.
What do you have to say about the contents of this affidavit?
It's true and correct.
True and correct. Shown pages 1 to 8 of the judge's brief. What okay. Just please see the document. What is this document?
These are the copies of bank statements download from the official website of United Bank of India, now PNB.
Copies of
bank statements.
What do these bank statements?
Now PNB.
Now PNB.
Now PNB. What do these bank statements show?
This bank statement shows the payment made by me to UK traders.
UK traders.
What is UK? What is UK traders?
UK traders is a proprietary firm of Uttam Chatterjee. Uttam Chatterjee.
Yes, next.
What do you have to say about the contents of these bank statements?
It's true and correct.
This may be marked as an exhibit.
Exhibit A. Collectively. और ये तो कंटिन्यूएशन है ना, अलग अलग है. No, no.
Yes, this is CS.
This statement, this bank statement is continuation or collective?
No, sir. Separate.
Separate.
Collectively, Malad. Because they pertain to different dates, Malad.
Okay.
Companies are also different, sir.
Yes, next.
Shown pages 9 to 1220 of the judge's brief of documents.
आप लिखना चाहेंगे?
Sorry. Wait, you have to play what place.
में कौन था?
77
नहीं तो यहाँ पे तो लेकिन दिवेश कॉपी ऑफ कॉपी है 78 का.
देखो ना, ये तो आने लगा रहा.
78 है, CS 78 है, affidavit है, copy আছে, copy আছে. বলো দিতে বলো. CS 78 है. No, but the affidavit that has been given today, I need a copy of that affidavit, no, for myself. You have a copy of this affidavit? ये तो रहा
No, no, this is.
Agarwal, who is the director of Devesh as well as Hightone.
I know that this is not the affidavit of evidence. The affidavit under 65B. Ready? What are these documents from pages do to number in so and so to so and so?
21220.
These are the copies of agreement for sale entered by Uttam Chatterjee with the third party with whom you have done purchase these properties.
Purchase the properties.
Downloaded from the official websites of Government of West Bengal, Directorate of Registration, Revenue.
Registration and revenue.
Downloaded from the
Website.
Directorate.
Directorate.
Directorate of Registration, Stamp and Revenue, Government of West Bengal.
Yes, next.
Whose funds have been used for entering into these agreements?
My fund.
My funds.
The payments that I have made to him.
That I had made to him.
What do you have to say about the contents of these
it's true and correct.
agreements?
Yes, next.
Well,
X for identification.
Shown page 1221. Of the judge's brief of documents. Milord, I believe your lordship has not closed the chief in item 77, the earlier matter. Has your lordship?
I will record the evidence.
Yes, my lord.
What do you want?
Kindly don't close the chief.
Why?
My lord, documents are very voluminous. My lord, I will evaluate and then one more day, 5 minutes, I will close it, my lord.
Yes, continue.
I may have to ask, as I said, my lord, few more questions. Kindly just leave that window open, please. So grateful.
It's the same complaint which was lodged and which we've already executed.
So, okay. 1221. What is this document?
So this is the received copy of the checkbooks that has been lost from my office, given to officer in charge, Neolipur police station.
Sorry, come again. Ki bolle che? Can you show me the document from your brief? Can you show me 1221 from your brief? This is the receipt copy of the complaint.
Complaint of.
No, receipt copy of checkbooks. ठीक আছে. If what?
Sir.
One moment. This is a received copy.
That has been lost given to officer.
I believe this answer has been misunderstood. It's a complaint about loss of.
This is the complaint lodged by me. You are lodged?
Yes, sir.
This is a complaint lodged by me with respect of loss of the checkbooks from my office to the officer in charge of PS so dated.
So it's 7/9/19.
7/9/19.
2007 September 2019.
2019.
Who has signed this complaint?
Sir, I have signed it.
What do you uh, what do you say about the contents of these documents? What do you have to say about the contents of this document?
That's true and correct.
Show no
The
receipt.
police received the same?
Yes, sir.
Is there any GD entry?
No, sir. It's
Number?
GD was not done, sir. They have just received.
Receipt copy is there?
Yes. To the court. So, my lord, it may
To
go
the
in.
court.
To the court.
Done. Not done, only they have received my complaint.
They have received my complaint. The original. Shown the original.
The complaint.
Please identify this.
So this is the letter, original letter dated 7.
This is the original document.
Dated 7
Exhibit B.
September 2019.
Exhibit B. Grateful.
Next.
Yes. Shown pages 1222, 1222 until 1236 of the judge's brief. दिखाएं एक बार. No, 90. Volume 9.
No, no. It will be 1, 2,
1, 2, 3, 6.
3, 4.
Up 3-6 तक देखिए.
Sorry. To 1, 1, 2, 3, 4. 1 222 to 1, 2, 3, 4.
Yes. Yes, what is the question?
Yes. What is this document?
So this is the notice given from my side to Uttam Chatterjee to refund the money that I have paid to him. And the next are the, sir, speed ports receipt and track reports.
Who has signed this notice?
Sir, my staff, Priya Rai. Sir, my staff,
Priya Roy.
Priya Roy. How do you identify Miss Priya Roy's signature?
This is her signature. This is a regular signature, sir.
This is a regular signature. What do you have to say about the contents of this document?
That's true and correct.
This may be marked.
Exhibit C collective.
Collective.
On the original.
These are the original document marked as Exhibit C collective.
This is the original.
Yes, next.
Yes. Shown page 1237. I know that. I'm not dumb.
I'm not saying that, I'm sure.
1235. Shown page 12.
Before exhibit, so this is the original document marked exhibit. Okay.
Exhibit C, Malad.
Shown page 1235 and 1236.
Yes.
One. Dada?
Yes,
Shown page
1235,
1236. Yes. What is this document?
So this is the reply from the advocate of Uttam Chatterjee against the notice sent by me.
How did you receive this reply?
In general course of business.
Shown original reply. Please identify the original document.
This is original?
Yes, sir.
Reply. Reply.
Exhibit D.
Exhibit D.
Next.
In my lord. 1237. Shown page 1237. What is this document? What is this document, sir?
This is a ledger of the payments made by me to UK traders, prepared by me from my computer.
Have you cross-checked the entries in this ledger with your bank statements?
Yes, sir.
What did you find upon cross-checking?
There were no discrepancies. But it was matching with the bank statement.
There were no discrepancies. It was matching with the bank statement.
Yes.
What do you have to say about the contents of this ledger?
It's true and correct.
True and correct.
This is the original.
Office copy of the ledger.
This is the office copy. Marked as exhibit E.
E.
Next.
E. Last. Shown pages 1238 to 1293. What are these? What are these documents?
So these are the cancellation of agreement for sale, which we have done previously. There are two copies of cancellation.
Please.
These are the two cancellation agreement for sale which we have.
Which he have entered previously.
Which he have, my lord.
Which we have.
Had.
He
had. Sir.
He had entered previously
with the buyers.
With the purchasers.
He meaning?
Uttam Chatterjee has.
Should that go in as a question or can the answer? Whom do you mean by inverted commas he in your
Uttam Chatterjee
previous answer? In your previous answer, Uttam Chatterjee. ठीक है कितना बार बोलेगा नहीं কি হলো একটু বলো না আমাকে
Yes, next.
Where have you obtained these agreements of cancellation from? Agreements of cancellation of sale from? Where have you obtained these agreements of cancellation of sale from?
I have downloaded it from the official websites of the Government of West Bengal, Directorate of Registration,
yes,
Stamp and Revenue.
What do you have to say about the contents
of
these agreements? True and correct. X identification.
Mark X1 for identification.
78 is more or less done. One more day, my lord, I'll conclude, Chief. I'll take necessary steps. In 78 and 77 and 79, can I rush through it? Unless your lordship is tired.
Not tired, other matter is fixed. Lordship never tired.
It's open. We debate. Wait, my lord, I'm so grateful. My lord, if all three can be kept on another day, then I can finish 79 altogether and also finish.
So appearing for.
Thank you, sir. Oh, my lord, may I also
take.
Please, I'm sorry. Yes, shown electronic evidence. Affidavit under section 65B of the Appendix. What is this? What is this document?
So this is my affidavit for electronic evidence.
Who has prepared this?
My advocate on my instruction.
Who has signed this affidavit?
Sir, I have signed.
On which page does your signature appear?
Sir, the page number 3.
What is, on which date have you affirmed this affidavit?
17 January 2025.
Page 3.
On which date have
17
you
January 2025.
What do you have to say about the contents of this affidavit?
So it's true and correct.
Exhibit F.
So grateful, my lord.
So suffering for the plaintiff. Plaintiff witness is present. Okay, 7 and 8. 9 May. Definitely. Witness present. Examination during the examination chief of the plaintiff witness. Documents were marked as exhibit A to exhibit F, na? Exhibit A to both. Exhibit A to exhibit F and X for identification. X and X1. X and X1 for
the agreements and the cancellation documents.
Full stop. The examination chief of the plaintiff witness is defer. Full stop. Yes, when you will bring? Let the matter appear on
When can you come?
12th March, 3 p.m.
March.
12th March, but your audit period is there.
My lord, can your lordship accommodate me sometime in February? Subject to the
time you will
court's-
not get. That is the I can fix it, but you will not get the time slot.
I will. Very well, my lord.
So what I let you, I am fixing and you give the subpoena, let the witness come, then you can complete this.
Very well, my lord.
That will be better for you.
So
give
12th.
the subpoena.
Yes, my lord.
Let the subpoena. If the document come, then he can explain the document.
Yes, my lord.
That will be better.
Very
12th March.
So
at
12th March. In the meantime, we'll take
12th
steps.
March, 3 p.m.
3 p.m. Grateful, my lord.
9. Item number 9. Due to paucity of time, evidence could not be taken up.
I had a doubt. I thought I'll give it a try. I'll be very frank. But I got caught.
Due to paucity of time, witness could not be examined.
No, no.
Exam. Case adjourned 12th, the same day.
Grateful, my lord.
Witness.
Yes, sir. Examination key folder, please.
Contesting.
Yes, my lord. With counterclaims.
Oh.
My lord, may I file the judge's brief of documents? I'll hand over a copy to my lord.
Thank you.
My lord, I'm being led by Mr. Chaudhary. He'll be here, my lord. I'll just start.
You came earlier also. Continuation.
No. Start. I'll give first.
First time.
First time.
Okay. We repeat after me. I
I
solemnly affirm that
solemnly affirm that
in whatever
in whatever
I will depose
I will depose
by way of evidence
by way of evidence
in this suit,
I shall
speak the truth
speak the truth
and no part of it
and no part of it
shall be false,
and
I shall not conceal anything.
conceal anything.
What is your name, sir?
Rishi Karnani. Karnani.
Father's name?
CK Karnani.
C.K.
Karnani.
Your age?
49.
Occupation?
Business.
Residential address?
40 Panditya Road.
Panditya
Road. Kolkata 29.
29.
Mr. Kanani, how are you related to the plaintiff company in the instant suit?
I am one of the directors of the plaintiff company.
That I'm being led by Mr. Yes, first. Mr. Kanani, are you aware as to why the plaintiff company has instituted the present suit?
Yes,
Could you tell my lord why the plaintiff has instituted the present suit?
we have instituted this present suit for eviction of the trespasser.
My lord, I'm being led by
Delivery of vacant and khas possession. And delivery of vacant and khas possession.
Yes.
I am showing you the original document disclosed as PD number 1 in the judge's brief of document. What is this document?
This is the board of resolution.
The board of resolution.
Dated 28 November 2024.
Who has passed this resolution?
The directors of the company.
Whose signatures are appearing in this resolution?
Sudarshan Karnani, Aditya Karnani, Rishi Karnani, Aditya Karnani, Rishi Karnani, Akshay Karnani.
Are the contents of this document true and correct?
Yes.
My lord, may I tender it? Exhibit A.
Exhibit A.
I am showing you a certified copy of the document being PD2 in the judge's brief. What is this document?
This is the title deed dated 5th November 1966.
Can you tell my lord, this is the title deed pertaining to which premises?
This is the title deed pertaining to various premises comprising of which commonly known as Kannani Mansion. Various premises.
Commonly known as
Comprises of various premises commonly known as Karnani property.
Including 43 Park Street, 47 Park Street.
But since this is a certified copy, my lord, may I tender it? Exhibit B. Tendered and marked
Exhibit B.
Wait again.
Certified because the original was exhibited in a different suit. This is certified copy of that exhibit.
I am showing you a certified copy of a document dated 11th October 2018. What is this document?
This is an exhibit which has been obtained from a certified copy, which has been obtained from another suit, and this is pertaining to the amalgamation of the premises, namely 29, 31, 33, 35, 37, 39, 43, 45, and 47 Park Street into 47 Park Street.
Who has issued this amalgamation certificate?
This was issued by Kolkata Municipal Corporation.
You just now referred to the exhibit being, sorry, you just now referred to, you just now referred to the certified copy being obtained from the records of another suit.
Yes.
Can you tell my lord what this another suit refers to?
This another suit is between Kannani Properties Limited and Mehra iTech Private Limited, which is iTech Private Limited.
Where is the original of this amalgamation document? The certified copy whereof you are relying?
The original has been filed in this suit that I have referred to.
Lord, may I tender this document, my lord?
Exhibit D.
Exhibit D.
C.
D.
Huh?
C.
C. Exhibit C.
আমি মালিক হয়ে গেছি হ্যাঁ জানি এক্সিবিট সি হ্যাঁ আমি কেউ নেই
I am showing you an original document dated 9th September 1957 being PD number 4 in the judge's brief of document. এটা জ্যাকেটের সময় দাও পুরনো তো একটু ব্রিটল আছে What is this document?
My lord, this is a letter issued by Calcutta Carpet Store dated 9/9/1957 to Kannani Properties Limited, in which one of the partner of the firm has intimated us about the death of Mr. Ramchand, who was one of the partner of the Calcutta Carpet Store.
Did you receive this? Did the plaintiff receive this letter in usual course of business?
Yes.
My lord, may I tender it?
Exhibit D. Are you taking advantage of the fact that I'm junior?
D. I am showing you an original document dated 26th November 1957, disclosed as PD number 5 in the judge's brief. What is this document?
This, my lord, this is another document, letter which was issued by Calcutta Carpet Store, dated 26/11/1957 to Karnani Properties Limited, in which they have issued the no objection. The legal heirs have issued the no objection in we changing the name to Calcutta Carpet Store.
Whose legal heirs have issued this no objection?
Mr. Ramchand.
You just now referred to a change of name. The change of name is pertaining to whom?
Previously, the agreement was between Karnani Properties Limited and Hasmat Rai and Ramchand. And they wanted it to be in the name of Calcutta Carpet Stores.
Did you receive this document in the usual course of business?
Yes.
Lord, may I tender it?
Exhibit E.
I am showing you an original document dated 10th December 1957.
কাস্টডিও করলে না সইও করলে
দরকার নেই
সবাইকে বলবো
ঠিক আছে
He's not proving custody, he's not proving signature, and he's exhibiting, taking advantage of the fact that he's senior to me. I'm going to complain to everybody else. This evening is Mr. Shuman Datta's Minad function. I'm going to go there early and tell everyone. That's what he deserves.
You bring another senior.
I have to now.
But if you, then you will be getting ready.
His document received in usual course. I'll start proving the signatures and all. The first objection he'll raise. How does he know?
Now, if Mr. Chaudhary is not objecting, it can be.
Yes, I'm not objecting in the matter.
I am showing you an original document dated 10th December 1957, being PD number 6 in the judge's brief. Please tell my lord, what is this document?
This is the tenancy agreement dated 10th December 1957 between Karnani Properties Limited and Calcutta Carpet Stores of 43 Park Street, Calcutta 16.
Subject to what my learned friend says, Milord, I'm sorry to interrupt. But now, Milord, in 2025, we should file affidavit of evidence and not object to documents, Milord.
Milord, in fact,
Actually, what I am telling with regard to the evidence, Order 18 Rule 17 is not in the order, but it can be. It is not that it is bar.
No.
It can be. And with regard to the document, as proposed by, I don't want to
put it in the
part of the document you relied upon, put the document, list of document along with the application, or it may be exhibited.
Yes.
If any objection, then the other party can raise objection, otherwise it can.
Now, Milord, law is very clear now
that unless it's an inherently inadmissible.
That is order 18 rule 17
Yes,
says.
inherently stamped. Then your lordship will decide. Otherwise, I try.
That or any document which object.
Yes.
Object. That
But
okay, you
an
have to prove.
objection must be serious
So that's
objection.
why seriously with regard to it is has to be proved. Otherwise it can be.
My lord,
It could be.
If my learned friend admits, my lord, we can, my lord, mark these documents by consent.
You file your affidavit of evidence. Now, what is the? I'll agree to it. I'll never, my lord, object.
My lord,
Because
I
that
understand, my lord. The difficulty is I'll indicate, since this is, if it would have been a commercial suit, my lord, the law now permits us.
Correct.
But my lord, since this is not in the commercial division, my lord, because of earlier judgments, my
That
lord,
is the problem.
that is the
That's-
problem, my lord.
that-
But my lord, what will happen is we do not know, my lord. I may not be there for the plaintiff, my learned friend not be there for the defendant. Somebody else will come, and the first
They will take
objection that will raise is this.
my lord, when Justice Gupta, my lord, Justice Girish Chandra Gupta started taking up suits, he gave directions to file affidavits. Then, my lord, Justice Pinaki Ghosh's division bench judgment is there that unless it's without consent, that's my recollection. Unless without consent, you can't file.
No, my lord, I recall Justice Ghosh's judgment, not consent, my lord. My lord, that
Putty
was
Bhara.
set aside. Justice Gupta's order was set aside, relying on, my lord, that mobile tower
Gemini
case.
Silk.
Yes, my lord,
Gemini
holding
Silk.
that original side rules does not permit, my lord, that affidavit evidence, Justice Ghosh's. That is the difficulty.
But see the time wasted.
What can be done unless it is reviewed?
My lord, one thing can be done. My lord, if they give consent, the judge's brief is there. My lord, if they give consent, that documents can be marked by consent. We'll
in
also
other
give
cases,
our
Mr. Dutt was there and Mr. Ghosh was there. I had done the same thing.
Yes,
If
yes.
you are admitting, let it be exhibit 1, 2, 3, whatever it may be. Then
by consent, we can mark it
can-
as exhibit.
it can be
Yes.
exhibited. The time saved.
Lot of time will be saved.
Time saved.
I
Then-
just
You do one thing, other Mr. You give the water. Already judges will have
he
documented
must
with
be
you.
there.
Yes, yes, we have given them all, but both their document and our document is there.
So if it is not objected, it may be marked as exhibit serially.
না না কেন দেবে না শি ইজ না না তুমি এখানে অসুবিধে কি কিসে আছে আমার তো
He is the master of evidence.
yes yes no, I actually didn't know the suit would be taken up today but সবের অরিজিনাল আছে তো
হ্যাঁ
করে দিন না মা
হ্যাঁ টিডির অরিজিনাল তোমার কাছে আছে
সেটা বাদ দাও না। তোমার পিডি সব অরিজিনাল আছে তো
সব আছে শিওর
let it be marked
ওই শুধু এইটা তোমার সার্টিফিকেট অফ ইয়ে হচ্ছে ডাউনলোডেড কপি ফ্রম দ্য ওয়েবসাইট
that's fine
MCA website.
that's fine let's not
Let-
somebody
let-
else can
let
use
them
the
write
time
a letter, my lord. Next day we come and by consent it can be marked, and
Yes.
I'll also try to see if the defendant's documents, whatever is there, my lord.
Do
we'll
one thing. These are the document you going to mark exhibit. If you have any objection, then you
notice
will
to admit
notice to admit. That's
it is there in CPC also
that can be. There is every provision.
কি
admit করেছে সব কটা।
Milord, but your lordship, Milord, three prayers, Milord, I have. Number one is chief should stop. It's not done in 2020.
My lord will
Of a way of
not
doing
do
it.
that, my lord, because my lord, here my learned friend is there, I am there. It's different.
That's why.
But other cases, lordship will be in
It
difficulty.
will be difficulty. That's why I'm
No,
not
lordship
taking.
must think of a way forward. If required with some amendment or some practice direction, lordships have many administrative
Because now
powers.
I am taking testamentary, I find that 283 is still going on.
Yes.
In spite of
Second thing, Milord, and we look forward to your lordship taking steps. Second, Milord, matter is ready. Document disclosure, matter is ready. Commissioner appointment referred for commission. There should be, unless it's a probate matter, no evidence before your lordship. Only final. That's what is done in Delhi, Bombay, everywhere.
no Delhi, what the Delhi doing? Delhi is having the registrar.
Yes.
Once it has come to the witness action, they are sending it to the registrar. Registrar will examine the witness, sending the file to the argument.
Yes. So
And
same
if any,
system.
any objection with regard to the document, it will be exhibited with mark as per or whatever with objection. The court will decide
And
during the
registrar acts as the commissioner.
Correct.
So here, if we don't have registrar, your lordship will direct my lord's officers because there is no adjudication by a commissioner.
No.
And
That's
senior.
Many of the commissioners are coming. They are nothing doing. They write the objects, and the court will decide whether
Correct.
it will be
And
admitted.
Milord, the third request is that these commissions, Milord, should start at 10:30 and finish at 4:30.
But where is the space?
Milord,
Problem
there
is
is
the
that
space.
new building. I'm sure there is space, Milord, somewhere.
My testamentary department is not having a space. They are sitting with the whole bunch of the document down.
Well,
There is
parties
no
can around this area find conference rooms.
There is no
That is
space.
available.
If it is 2-3 space, I will get, then immediately do that. And I will fix the time also, so that the matter
Yes,
can
because
be-
last time I remember they all ganged up against me when I said 10:30 to 4:30.
So
that commission took 1.5 years to get over.
No, still that is a problem. They are asking every time. They are asking for the time.
We'll find your lordships because what we don't realize is
Find the office. I will do that. You find the
will.
space where the commission can be done.
What the original side bar has to realize is unless suits are decided, the original side can never flourish.
Don't know. I am only for the last 2 years here.
But suits have to be the clients must get confidence. I will file judgment.
Save time, my lord, if lordship keeps it next week, I come with the, I'll sit.
Mr. Chaudhary,
next Friday second half কোনো দিন মামলা করতে পারে না
আমি
হ্যাঁ সাবস্ট্যান্ডার্ড গল্প রয়েছে
Lord, next Friday, if lordship's time permits, man. আছিস তো তুই?
আমি সব সময় আছি শোনো তুমি যে বলছো এটা করাও গিয়ে কমিশনের জায়গা থেকে
তুই বলছিস বটে ওনাকে করিয়ে দিবি তারপরে অন্য ম্যাটারে এসে অন্য লয়াররা অবজেকশন দিবে
প্র্যাকটিস ডিরেকশন করাও তুমি তো
Let this document be
yes.
complete.
কতটা গেছে লাস্ট আনসারটা?
না না কেন কোথায় যাবে যেও না
Because there is one aspect that it is far away in our Bijan Bhavan. There are two good spaces on the very far.
আনসারটা গেছে তো?
Otherwise, it can be utilized.
That's the only way suits can be heard.
That is very good. There are 2 rooms in the ground floor. There are other gates.
এটা এক্সিবিট করে এটা এক্সিবিট কত হলো এফ হবে না?
I had a talk with the chief also, but there is some distance, 20-minute, 30-minute distance.
Yes, half an hour. And this honorable court has by a judgment held that commission matter of course
Can be done. So if all that can be utilized, that space can be utilized.
You have to take some steps. Can't just stand and nod at me.
Now the secretary of the
Secretary of the bar. We worked hard enough to make you the secretary. Now you please do
Lord, I
something.
am just coming from, my lord, I was sitting with Mr. Jayanto Mitra at the upstairs library. I have some issues regarding, my lord, membership of 2 members. We were just
I have
sorting it
many
out.
issues against you.
And my lord, now this is there. My lordship keeps it next Friday, my lord, we'll be.
Okay, you complete this. You complete.
Yeah, we have completed. Well, this has been exhibited.
Okay.
কবে কটা?
Next Thursday, my lord, she says she's not there. Next Wednesday, my lord. It will take 2 minutes for it to get completed. I'll admit all documents.
Thursday is holiday. 23rd.
Wednesday?
Wednesday.
Wednesday or Monday, whichever is lordship convenient. Whenever.
Yeah, 20. I am fixing on 27.
Very well, 27.
So occurring for the plaintiff. So occurring.
27.
What about 11 a.m.
Whenever your lordship says.
Whenever lordship.
Occurring for the plaintiff. Plaintiff witness is present during his examination. Kitna document? Documents were marked being exhibit A to exhibit F. Exhibit A to exhibit F. Due to paucity of time, examination chief could not be completed. According chief is therefore let the matter appear on 27th of January at 11 a.m. At 11:30, na? 11:30.
এটা তুমি করো
For witness action. Na? Yes.
Lord, before rising, my lord, may I permit to mention item 5, which is fixed as 3:45. If my lord, your lordship can fix any other day, and if it is possible in the morning shift, my lord, 11:30 or like that. My lord,
No. I am for the Mr. Meghnad Datto. Mr. Meghnad Datto is leading. Your lordship fix any date and time.
What is the argument?
For argument.
They have completed. My argument is going on, my lord.
2 days already complete. 1 day.
How much time you will take?
1 hour.
1 hour? Then come in the March.
No, my lord. Any day, any day, my lord.
ये तो कोई है नहीं, कोई 345 है? 18th February at 3:45.
Well, instead of 340, it will earlier. Otherwise, if any resolution pass, your lordship knows same thing will be happen.
My lord, with your lordship's leave.
Item number 5. So and so appearing for the plaintiff, so and so appearing for the defendant. Full stop. Due to the bar resolution, and then, though the matter is fixed today, especially fixed today as 3:45 p.m. for argument, but due to the bar resolution, the matter could not be taken up for hearing. According cases adjourned, let the matter appear on 18th February at 3:45 p.m.
My lord.
Yes.
My lord, under extreme circumstances, my lord, I'm mentioning, my lord, item number 3 in the morning, my lord has been pleased to dismiss. My lord, I have no difficulty with the dismissal, but my lord, I have in fact instructions for withdrawing. But my lord, there is a counterclaim in that suit. So my lord has dismissed the suit with the application, but the counterclaim remains. My lord, if your lordship is pleased to record that the counterclaim is also gone, my lord, then everything will be complete.
15 number kon diya?
Item number 3, my lord, in the morning. My lord, I'm sorry I could not reach on time, my lord. I have instructions from my client, the plaintiffs, to have the suit withdrawn. But there is a fictitious counterclaim.
If it is a counterclaim, if you are withdrawing, then what about the counterclaim?
Counterclaim remains. So if that is there, so my lord, kindly include counterclaim also.
The suit is dismissed. It is fine that item number 3 record. उसके पास order होगा, हाँ? Sumona. It is fine from the record. The defendant has also filed a counterclaim.
Defendant number 1 and 2.
Defendant number 1 and 2 also filed the counterclaim, but even the defendants have not appeared to proceed with the counterclaim. Accordingly, counterclaim is also dismissed.
My lord, 345.
Dismissed for default.
345 would be risky, my lord, like today, my lord.
Then come in the March. I will fix at 12 noon or 2 p.m., 3 p.m.
Then I will try if.
That's I'm telling. Because prior to that, all blocked.
All booked.
All
Slots
booked.
Then
morning so booked.
All slots booked. And then afternoon.
Might need show only. That is only with you.
Earlier there was 4 o'clock matinee and 2 o'clock matinee shows.